Hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, down sitting at Boston, within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everybody, and welcome to the sitting of the Appeals Court in Courtroom 3 on Tuesday, September 12th, 2023. Your panel for today is me. I'm Greg Massing. To my right is Justice Vicki Henry. To my left is Justice Robert Brennan. We have read all of your briefs, so we're ready to get going. For those of you who haven't been here, or a reminder if you have, there's 15 minutes per side, no rebuttal. At a minute and 30 seconds, the yellow light will go on. When you're done, the red light goes on, and then it starts counting up. So sometimes people say, I've still got a minute left, but actually it's after red, it's going the other direction. So feel free to use all your time, but also feel free, if you feel you're done, to stop. There's no penalty for finishing early. One other item is that we all have your materials on these handy tablets, and so when we're listening to your arguments, we might be scrolling through stuff, and I assure you we're looking at record documents. We're not surfing the web, or apparently there's some really great clips of a football game last night that we're not be looking at that. So with that, I'm going to call the first case, which is Commonwealth versus DEJESUS, 22P932. And pardon me because I'm logging into my handy tablet.
Good morning, Your Honors. May it please the Court, Alex Conley on behalf of Vicente DEJESUS. This is a case that was a resisting arrest case that essentially turned into a case about a firearm that didn't actually exist. There was never a real firearm anywhere in this case. Yet, despite that, this case revolved around firearm, gang evidence, and other evidence that was not relevant, or if any relevance was not admissible because it was outweighed by the prejudicial effect.
So there was a BB gun in another vehicle. It was totally unclear from either one of you whether that vehicle was at the apartment complex at issue and when it was discovered. Can you?
Correct. There was a BB gun that was discovered in another part later on through a search warrant for the vehicle after the fact, after this investigation.
At that apartment complex or just some other vehicle somewhere?
My recollection is that it was at the apartment complex, so there was some tie known to the parties that the BB gun might be connected to him because it was a search warrant for the car that was parked in the parking lot there. But that didn't come into evidence. Obviously, the fact there was a BB gun didn't come into evidence. Instead, what came into evidence was that there was a firearm investigation.
So the Commonwealth says that this was relevant to set a context for why 5 police cruisers rolled up on this guy and why the officers approached with their firearms drawn.
Yeah, I understand the Commonwealth's argument there. Your Honor, I think for a resisting arrest charge, however, the way they appear at the scene and why they appear isn't actually relevant to resisting arrest, even to unreasonable use of force, because they're just, how they arrive isn't force they're using. It might be their show of authority.
I can't hear you very well, so I don't know if it's speak
perhaps
up
it's the
or...
show, is that better?
Yeah.
Perhaps it's the show of authority, but the show of authority and how they show that authority isn't relevant to whether unreasonable force was being used to actually arrest Mr. DEJESUS. So I don't think that has any relevance at all. And then even assuming that there is relevance at all to why they were there, to have the evidence come in that there was a firearm investigation was unfairly prejudicial.
I want to break that down a little bit more. So they show up with the weapons drawn, and he doesn't respond to their command. So you're saying it doesn't matter why they're standing there with their weapons drawn?
I don't think that matters as far as why they have their weapons drawn. That's not a factor or an element of resisting arrest. It doesn't even go into the self-defense argument for show of reasonable use of force to defend that arrest.
Well, so she's going to say in a minute, I'm just predicting, that it does matter because the amount of force he can use is related to the amount of force they're using. And if they're using too much, he can use some force.
And I would agree with that. And that's why I think if this was limited to the evidence that they actually observed and they saw him refusing to put his hands in the air perhaps, or him reaching under the seat, that would be admissible evidence to why they used the force. They were afraid for a weapon. Officers are always in any stop afraid for a weapon, especially if there's somebody making furtive movements. Certainly their fear may be exacerbated, but their use of force wouldn't be otherwise justified just because it was a firearm investigation versus another kind of investigation. I don't think them pulling up and drawing their weapons is an inherent use of force to which the defendant is resisting. He's instead resisting their commands subsequent to that and their actual physical use of force upon him.
Mr. Conley, why isn't the fact finder entitled to have some context? Just to understand what's happening here.
I think they are. And I think that trial counsel in this case suggested other kinds of context to put into it that's less prejudicial. Say it's a felony stop. I think the Commonwealth's own brief says that...
Doesn't Judge McCabe then say, well, geez, what if they think a felony stop means they're investigating a murder or a sexual assault? I don't know if those are the exact words. Isn't that potentially more prejudicial?
Certainly. I think that could be an issue, as to especially if it's left completely unspoken. I think the Commonwealth's brief says assault with a dangerous weapon could be used, and that would be something that would entitle them to do something which was a charge, but not as prejudicial as a firearm.
And why isn't the prejudice cured, at least in some way, or offset by the testimony or the evidence that there actually wasn't a gun found?
Well, because the testimony as far as there not being a gun found was very vague. Basically, there wasn't, especially when it comes to the closing argument, we get into that later, where it talks about how there wasn't a gun found in that particular car type of situation. But despite there being no evidence that a gun was found, there's multiple references to firearms throughout this case. And I think I counted in the closing argument 22 references to a firearm or a gun in the case that there was no firearm or gun. So I think that exacerbates the prejudice.
Although, in any of that situation, is it linked to your client? I mean, there's, you treat it as a prior bad act, but it's actually not really an act of your client. It's the state of mind of the officers.
Well, the question then is what is relevant as far as the officer's state of mind for this case? No,
but in terms of prejudice, like, I understand there's tons of reference to the gang unit and firearms, stuff like that, but is there a spillover that in the Grant case, there's a warrant for his arrest that suggests that he did something else. But here there's no suggestion necessarily that he did anything else, or that he's even a member of a gang, anything like.
Certainly. I think there's certainly no explicit reference to such. There's no explicit connection. I think that a jury listening, logical inference, they're responding to somebody waving a firearm and they immediately approach this vehicle with this defendant and draw their firearms and start coming at him in the certain way they do, that's related to this defendant. It's not some unknown firearm investigation. That wouldn't be logical connection for the jury to make. And especially where, although some of the evidence was struck, the very first line of the Commonwealth's opening, which was struck immediately, was this defendant waved a firearm, and I don't remember the exact wording, but waved in the face of two people. So I think that is relevant, and the jury's not going to be able to just completely dispel that. And all of this kind of prejudicial effect is exacerbated by the other evidence that came in, such as the gang evidence. And
so can I ask you about that?
Yes.
Let's say if it was on the homicide unit. And there's no thought that they're investigating a homicide here. There's no dead body. So the fact that the officers happen to be affiliated with a gang unit or had experience on a gang unit, how does that in any way, as Justice Massing asked, how does that impact your client as opposed to just being sort of general background? Or if he was on the domestic violence unit and there's no indication there's any domestic violence or relationship between partners in this situation?
Well, I think what that gets at, Your Honor, is exactly why it's irrelevant. It shouldn't have come in. It is an irrelevant piece of information that there's gang unit involvement here.
You don't think it's relevant to know whether this guy's been 30 years just a beat patrol officer or 1 year on as a patrol officer in terms of developing who the witness is as opposed to someone who has some sort of experience, some breadth of understanding of what it means to be a police officer?
I think that would be the case. And I think that's what the judge's decision on the motion to eliminate was trying to limit that evidence to that. Say, sometime in Officer Brady's tenure, if they were on the gang unit, they can say that. What I don't think the judge anticipated, and what actually came into evidence, was multiple references to this was the gang unit responding. We got a call from the gang unit to respond here.
Can I ask you one other question on that, Mr. Conley? If my memory serves me, The defense called a police officer who also happened to be a member of the gang unit, and the defense attorney elicited that experience as well.
They did. That come in. The defense attorney asked questions about their experience and what they were doing at the time that came into the gang unit. I'd suggest that part of the reason for the defense attorney's not inattentiveness to that issue was they were under the impression that gang unit evidence was coming in because their motion in limine had been denied. So there wouldn't be so much point to try so hard to stay away from that testimony since the motion in limine had been denied.
Well, I have to ask you a rather technical question. So the motion in limine was limited to Officer Brady, and what your brief is about today is that there were so many references. I mean, so my question is did the motion in limine really save this objection?
Yes, sir. I think it did. Just the way the motion was basically to exclude certain gang evidence. The decision on the motion in limine was to limit it, and I think that it was.
Was that oral? It's not. There's notation on the firearm that's for context. Is there? What was the?
I believe that the oral decision on the motion limit was just that it's denied, and the judge said he can testify to the gang unit if it was anywhere in his experience. So I think certain aspects of when that evidence came in, I think you could say are going to be measured for a substantial risk of miscarriage of justice as opposed to prejudicial error. I think at least the initial mention of him being being in the gang unit is a prejudicial error standard. And I think if we were to come before this court with a motion saying this is ineffective assistance for not objecting to those, it would not be ineffective assistance because an ordinary fallible attorney might misunderstand that ruling and think
Right, no, it's more, do we look at it as prejudice or substantial risk?
Certainly.
So, I mean, actually, this is what puzzles me about this. Let's assume that we find that there's some problems here with the too much gang, firearm, officer sympathy, that type of thing. How do we, so there's like this kind of, the problem is it's a generalized prejudice because there's nothing that really links it to your client. And the issue is, for resisting arrest is, did he do certain things? So how do you compare the prejudice to the elements of the crime? How do we approach that?
I think that comes down to in this case is what I suggest is somewhat of a weakness in the Commonwealth's case. I mean, this isn't the kind of case where there's no real self-defense argument. The police were just arresting in a normal fashion and he resisted. Instead, this is a case where the police officers used a significant amount of force. So there was I would suggest a close call on a reasonable force argument. The officers punched the individual in the face. They kneed him in the abdomen to try and stop him. And on the flip side of that, the only testimony about his actual resistance is he used his body weight to push against the car, or he wasn't really coming out of the car seat at the time. So because of the closeness of that case, now the jury, which causes prejudice, is looking at this individual in a very different light, and not a light of just somebody who's being arrested, but somebody who could potentially have gang involvement, somebody who was brandishing a firearm, and then going into.
But it's not totally prejudicial. They acquit on the disorderly.
Yes, Your Honor. I understand that. I think the elements of disorderly conduct, however, are very. There was very scant evidence of any of that, so I don't think that would be something the jury could not reasonably say this is disorderly conduct here. There's almost nothing in the record that suggests disorderly conduct. So I don't think that necessarily means where one's a close case and one's not, that means they don't care at all.
Okay, so in assessing this, I know the Commonwealth's brief cites to the video. You don't really raise it in your brief, and neither party submitted the video to us. Looking at the video help us to determine whether there was prejudicial error here or not?
I don't think it would. The video, you don't see hardly anything in the video. That's the biggest issue with the video. It's just kind of audio. There's the video from the surveillance, which I don't think really captures anything at all. And the other video is just really audio. So you can't really determine the amount of force being used. So I don't think it's necessary to help with the determination of prejudice. I think the testimony in and of itself shows that. That would be my opinion on that particular issue.
So, but the Commonwealth argues actually that the defendant's video shows that he knew before the stop even started that that Officer Brady was a police officer. So what do you say to that?
I think that's correct. The video does show that. I don't think that really is relevant, however, to whether or not there was the strength of the Commonwealth's case in resisting arrest or the relevance of this prejudicial information. Whether or not he knew as a police officer, I don't think is in dispute. I don't think there's a question that he didn't think these were police officers coming behind him, and that's why he was resisting. The question for the jury was his resistance a response to the unreasonable use of force by people he knew to be police officers? I'd also just briefly note in my last minute here about the mistrial argument as well.
So how do we evaluate the mistrial if we can't hear the closing? Because there is obviously a difference between a prosecutor saying there was no gun found in that car or there was no gun found in that car.
Yeah. Yeah, sure. I think the context in the transcript gives enough for us to show that. I mean, the judge is very upset about the situation, how the Commonwealth phrased that, and it seems clear from the defense's objection how it was that there was some impropriety in how it was phrased. Certainly,
Those were the exact words the judge said that they could use, though, right? Notwithstanding the inflection issue, which, as Judge Henry points out, we don't know about, but the precise words used by the prosecutor in closing were the words the judge said could be used.
And the wording was the same. I think the inflection is an important part of it, is how that came across, how it was said. And the judge was like, you said that. You shouldn't have said that. I think that is enough context to know that was not just that. I know that sentence was very hard to even say out loud, but that was not that. But that's what I think is clear from the context. And additionally, the amount of times throughout the case, including the opening which was struck, including the 22 references to firearm in the closing, firearm evidence throughout the other evidence, makes this mistrial motion significantly stronger. And with that, seeing my time is up, I'd rest on my brief unless there's further questions.
Thank you very much.
Thank you.
Just in the nick of time. We'll hear from the Commonwealth.
Good morning. May it please the court. Jennifer Cullen for the Commonwealth. First of all, I do have a copy of that video that was admitted as Exhibit 3 for the court, if the court would like to have that.
You think it would help us determine then whether there was prejudice or not? Assuming, for the sake of argument, yeah.
I believe that it is helpful to show that the Commonwealth had a strong case and that there wasn't prejudice based on the cumulative alleged errors. I think it goes to corroborate the Commonwealth's theory of the case, that there wasn't unreasonable force used, but also that in the event the jury found there was unreasonable force, it went to the idea that the defendant, if he'd acted differently, if he'd obeyed the commands, the force would have ceased.
Let me ask you about the theory, and maybe it's more theme. Do you disagree that the trial prosecutor's theme appeared to be gun, 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 for want of a better way of putting it?
I believe
22 times, I think.
I believe that the prosecutor was very concerned about bringing to the jury's attention the state of mind of the police when they showed up on the scene. And I believe that was especially important because whether or not the police were acting under the color of their authority is an element the Commonwealth had to prove beyond a reasonable doubt to the jury. So they needed the context of what the police knew before they arrived on scene to make that determination.
So would it be if it were a trespass and the police came out waving guns, is it then your proposition that that would be outside the color of their lawful authority in that context? And it's different if they have information that there may be a gun?
I'm not sure that I would necessarily comment on that. However, I would say that whether it was a trespass would have been just as relevant as if it was this firearm investigation.
So you write in your brief that the police learned that a firearm was brandished by the defendant earlier that evening during a road rage incident. But when I look at your transcript site on pages 117 to 120, I don't see that it says that. I mean, it definitely at some point the defendant is associated with the incident, but the timing of it is not clear.
Your Honor, I apologize. That was my understanding of the facts of the case. Perhaps I cited to an incorrect part of the transcript, but my understanding of the facts was that the officers were aware that this was the defendant involved in that incident.
But, okay, so let's assume for the moment that it is. Why was it not enough to just say to the jury that, he didn't seem to stop his motor vehicle and he was reaching around under the seat, and so the officers were concerned there was a weapon? Why did we have to say gang, 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 gun, gun, gun?
Well, Your Honor, I believe that was important because I'm not sure that behavior without the police knowledge in advance of arriving on scene would necessarily justify how they reacted, because immediately upon stopping the vehicle, my understanding was that the officers got out of their car and used their doors as shields and drew their weapons. And so I think if it was just a generalized concern, that behavior wouldn't necessarily be explicable.
So what do we do with the fact that there is a difference between somebody saying there was no gun found in that car versus there was no gun found in that car?
I understand the conundrum that the panel is in with that. However, I would argue that the words, although perhaps not the most eloquent way of saying that there was no gun found in the car, were within what the judge had allowed the Commonwealth to say on the previous day.
I know it is outside the record, but have you listened to the FTR on this?
I have not, Your Honor.
So, I mean, it seems that the prosecutor is, as they say, sailing close to the wind there, or pushing up close to the line, and at the beginning and at the end, going over that line. Isn't this actually this case a good candidate for like a cumulative error analysis?
I would argue that it is not, for the reason that the case itself was strong, based on the testimony of the witnesses, including the defendant's witnesses, as well as that recording made by and submitted as an exhibit by the defendant. In addition, the jury did acquit the defendant of the disorderly conduct charge, so I believe that tends to show that the jury carefully considered the evidence.
What was the evidence of disorderly conduct?
I believe it was admitted that people were coming out of their homes or their cars. I'm not sure which one, but there was evidence that people were coming out of they were stopping and coming out to look at what was occurring.
Right, but that's just people being stupid because they see danger and walk towards it.
Well, and I suppose the argument was that the behavior on the part of the defendant led the bystanders to do that.
So on this error situation, I mean, we see actual gang murder cases where the word gang is not used in a 2-week trial. Like where there's no question that he was in a gang and it was a gang retaliatory murder and they don't use the word gang.
Yes, Your Honor. So
But what do we do with that? Because that seems awkward for you.
So I, of course, would first argue that the gang unit testimony purely went to the officer's experience and training. However, if Your Honors did find that admitting that testimony was done in error, I would argue that it was neither prejudicial error, or I would also argue that some of the statements made by the police officer, De Carvalho, would be reviewed pursuant to the no substantial risk of a miscarriage of justice standard.
So why can't the officer just testify to their training and experience as opposed to saying, I'm in the gang unit and this call went to the gang unit? I mean, because I don't know what the jury was supposed to infer other than that this man was a gang member.
I believe that the intention was to show that the officer received more specialized training in relation to making stops of this nature. Not to say that necessarily this was a gang stop, but that the officer may have been part of more trainings and had more relevant experience in order to make the decision to act in the way that he did.
So is it the Commonwealth's position that a police officer with children is more reasonably in fear for their safety during a traffic stop?
Your Honor, I would agree that that was probably not necessary to bring up. However, I would still argue that it was not, it didn't amount to a substantial risk of a miscarriage of justice. I think the case that I've cited and what has been cited by my brother is Gordon, and I would argue that what occurred in this case didn't rise to the level of what occurred in Gordon, and Gordon was not overturned.
So what's your best case that it was permissible to include this firearm context?
I would say either Commonwealth and Chalou or Commonwealth and Proya.
What was the second one?
Proya, P-R-O-I-A. I've cited that in my brief.
Thank you. Apparently, I cannot hear this morning, so I don't know what that's about,
I
but
apologize.
So you said at the beginning you thought that the video would help your...
I think it is helpful.
So why don't you agree with Attorney Conley to make sure that he agrees that's a true and accurate copy, and why don't you submit it to our clerk's office?
Yes, Your Honor. And if there are no further questions, I will rest on my brief.
so I just want to drill down a little bit into the closing argument, because the prosecutor specifically said you heard from Officer Brady, who at the time of this incident was a detective on the gang unit, and he told you about his training experience. And they didn't need to say that. They could have just said Officer Brady told you about his training and experience specifically in investigating firearms.
And Your Honor, I don't necessarily disagree with that. I think that would have been a reasonable thing to do. However, I would still argue that it's my understanding that the Commonwealth's purpose was to show the depth of the officer's training experience and just experience in general. And I suppose to show that he had been chosen for this unit would also kind of go towards his experience on the job.
Okay, no
I'll
more
rest my
questions.
brief.
No, so
Thank you.
thank you both for your excellent arguments, and the case is submitted. I was told to wait before calling the second case.
Yes, well done.
I was told to wait before calling the next case to give them a chance.
Okay.
Yes, the next case will be Commonwealth versus LYRIQ Rivera 22P717. Go ahead.
Good morning. May it please the court, my name is Jeff Garland on behalf of LYRIQ Rivera. I'm asking you to find that the police violated Mr. Rivera's rights in 3 ways. First, by strip searching him in public. Second, by strip searching him without probable cause. And third, by an excessive outer search frisk of his genital area leading up to and throughout the interaction.
And you only have to prevail on one of those, right? You don't need to prevail on all 3?
Exactly. So each one is independently sufficient to reverse. I asked the court to find all 3, but I only needed 1 to reverse. And they are all related, but they're also conceptually different. Personally, I think the simplest of the 3 is the public nature of the strip search, because it's just so unnecessary.
When you say that, may I ask you this? Assume for the moment that the officers reasonably believe that he's got 8-ball in his crotch. Are they to put him in the cruiser with the fentanyl and hope he doesn't ingest it on the drive to the station? Or what's their best choice besides what they did?
One answer would be to take him to the station. And
They got to get him to the station. So it doesn't answer my question in terms of from scene to station, he's in the back of the cruiser with what they pretty clearly believe to be a package of drugs down his pants.
Right.
Which turns out to be fentanyl, which we all know is pretty dangerous in general, but to the person who ingests it
So
in particular.
There are 4 officers on scene. They could have easily left 2 there, had one drive a cruiser, one either sit with him in the back or sit in the passenger seat, but sort of looking back, making sure he doesn't do anything fishy. Obviously, if he starts reaching his hands around somehow, that's a different story. That might amount to an exigent circumstance.
As a constitutional issue, let's assume for the moment, though, that there's a small town department, it's 1 officer and 1 defendant, and they got to get the guy off the scene and get him to the station. And the officer, again, is pretty well assured that that's drugs in his pants. Put him in the back of the cruiser and keep his fingers crossed while he drives 10 or 15 minutes to the station, or what are we doing here?
Yeah, I don't know of the exact delineation of exigent circumstances. I don't think the court needs to decide that here because it is so clear. I think as to that hypothetical, I think certainly the availability of officers is one factor. I don't know if only having 1 officer available is enough by itself without any other indication of any sort of fishiness going on. I certainly think it is a factor that could go into that circumstances. Okay. But this is a situation where it is...
Would it have been okay if they'd have brought a wagon and taken him inside the wagon and closed the doors and searched him?
That's the other easy scenario that the police could do. Again, it depends a little bit on resources,
ambulance.
But certainly Boston Police, there's no shortage of available officers that you actually see later on. There's a couple other officers in the body camera video that come. So there's no shortage here. And the case law that we cited includes both of those examples happening, where they either do it in the, they wait and take the person back to the station, or that they do it in a van, or as a case like Morales, where they don't wait, even though Mr. Morales is uncooperative, is sort of generous. He flees from the police twice, the second time violently, actually elbowing them and running away. They still say that's not enough to create an exigency. He still needs to wait. Police still need to wait until they get him back to the station and do it there. This is a case where they are on a public street. That's a major street. It's just middle of the afternoon to around 2:40 p.m. It's a clear day. There are cars going by. There are pedestrians going by. Mr. Rivera's cousin, Mr. Aristide, is standing right there. They actually bring him out of the car, and he's facing the area of the search. I don't think he can necessarily see down Mr. Rivera's pants, but as Amato says, that's not necessary.
Let me ask you this. Understanding all that, you're not suggesting that any private part of his body was exposed to anyone other than the 1 officer who was looking down to see where he was reaching, are you?
And possibly Officer O'Connor, who's standing.
Who was standing right next to him, right?
Yeah.
Okay.
I don't think the pedestrian necessarily can see down his pants.
Does that make a difference?
Amato says no. And so the Amato dissent raises that, and then the court below actually cites the Amato dissent sort of for that point. And the Amato majority specifically rejects that point, saying that the humiliating, demeaning, and terrifying experience that is the hallmark of a strip search exists even where the arresting officers are the only persons to view a suspect's intimate
So then
areas.
it would not have made any difference if this occurred on the street, in an ambulance, in a wagon, or in the station house during booking. No difference at all, because it would be equally, presumably, then based on that, humiliating and embarrassing.
I think the context of that statement is that they're still talking about it being in public, though Amato is much less in public. They actually do take him between 2 buildings. It's nighttime, so this is a much more public search. And this is a case where, unlike Amato, where it's possible that someone could have seen it, but it's a little bit speculative. Here, it's pretty clear Mr. Aristide, the cousin, sees basically what's going on, and there's the 1 person walking by, exactly. And
In this case, we do have the videos, and we've seen the videos.
so I'm glad. I hope that worked for the court. I know there were some initial technical issues, but I think it got through okay.
Yes.
Good.
So the Commonwealth attempts to distinguish Armato by noting that the police officer here relied on his experience to conclude that the defendant was secreting narcotics in his crotch. What do you say to that?
The police officer Amato said the same thing, and that based on his experience, he had previous experiences of feeling the same thing. I actually sort of structured my questions about that in cross, sort of following Amato and sort of paraphrasing Amato as I was going along, and that was sort of what what the evidence primarily was.
Well, that's on the, is that on the probable cause issue?
That's on the probable cause, so,
Yeah.
which is maybe a good segue to that issue. And so probable cause is also, it's pretty rare to have a case as on point as Amato is in a probable cause situation. And I would,
Amato's different, though, because in Amato, the police actually didn't have justification to do the pat frisk. And here, you're not saying that they didn't, that the pat frisk was not justified, right?
they had justification to do a pat frisk. They went too far with the pat frisk. So that's so part one of Amato is talking about sort of this is too much for a Terry frisk. Part two of Amato says, okay, if they'd had probable cause that this was drugs, then they could have arrested him, and it doesn't matter that, you know, the search precedes the arrest. It can still be a valid search incident to arrest. So the part two is assuming sort of basically it is a valid search incident to arrest, but it's not because they don't have probable cause and because it's public.
So if this were a search incident to an arrest for drugs, then a strip search in a public place would be okay?
The public part of it would still be a problem. So
Because I think Amato says essentially just like this, minor motor vehicle, no indication whatsoever of any drug related, as opposed to if they were doing a drug investigation or they smelled or saw something that would indicate drugs or something along that line. It's just interesting. Yeah?
I think if this starts off as an arrest for drugs,
Right.
then the fact that they find something in the crotch that doesn't feel like anatomy, that might get them to probable cause, but they still have to do it at the station or in the van.
Okay.
I mean, this is an arrest for not driving without a license, right?
Exactly. And so, segueing to the third.
Oh, so I mean, and there, so it's a search incident to arrest. It's not the and so are you saying that it exceeds the scope, that frisking around, you know, around his crotch exceeds the scope of a search incident to arrest?
Yes, and I thank you for the segue to the third argument, that it is, the frisk is excessive. And so, yes, Amato, as the Commonwealth points out, is a pat frisk case, not a search incident to arrest case. But number one, again, as I mentioned, that they sort of assume that if there was probable cause, then they could have been doing a search incident to arrest. And number two, I think the distinction collapses in light of Chapter 276, Section 1, which says that they can only search incident to arrest for evidence of the crime, which the Commonwealth concedes that there's none that they would find here, or weapons or items to means of escape, which sort of, I think, amount to the same thing here. There's no hint that this is weapons. So once they do enough of a frisk that they can tell this isn't weapons, you can tell pretty clearly on, you know, the frisk proceeds from sort of three locations. There's the frisk next to the car that Mr. Rivera had been driving. There's the frisk behind that, and then there's the frisk leading up to the strip search next to the cruiser. And it's pretty clear, but by the time the officer has been searching him on the exterior in the first place, next to the car that Mr. Rivera had been driving, there's no suspicion that this is a weapon, and there's no indication. He, specifically testifies that he didn't believe it was a gun. So by that point, they suspect, and I concede there is reasonable suspicion to believe the drugs or something like that.
What more do you think they would need here for that reasonable suspicion to escalate to probable cause to believe that there were drugs in your client's pants?
I mean, certainly, I think, again, if this had been a situation where they'd seen him doing something drug-related.
How is this different from any other plain field case?
Plain field case, I think the plain field argument is belied by the fact that it takes him 2 minutes to feel this. So this is not the plain field cases where they immediately, it's immediately apparent what they're feeling.
As you watch the video, do you really think he didn't know what it was or think he knew what it was when he touched it and was just trying to figure out how to get in there and get it out with the least amount of difficulty?
Again, I think at a reasonable suspicion level, absolutely he does, and his suspicion ends up being correct. But I do think it's pretty similar to Amato in that they have these factors. That it is I think Amato calls it highly suspicious, but just not quite there. And so, and to the extent that then he continues to search once he recognizes it's not a weapon, and it's clearly not evidence of the crime of arrest, then once he continues to frisk, that is itself a third violation of Mr. Rivera's rights.
So just for housekeeping, because it's much easier for us if you say it as opposed to us inferring it. So you are not challenging the exit order, right?
Right.
And you are not challenging that the police were entitled to search him incident to a lawful arrest, right?
Right. Not for
Okay.
today's purposes, yes. So I asked the court to reverse on all three grounds, noting that all of them are independently sufficient, but I think they all are sufficient. There are substantial violations of Mr. Rivera's rights, and also pretty directly addressed by SJC precedent.
And just one, so I'm, one more house. This is here on, SJC gave you leave to appeal interlocutory.
Exactly. So the case is still pending in next door.
Thank you.
If the court has no further questions, I will rest on my briefs.
Thank you.
Thank you.
Morning.
Morning, may it please the court. Ian McLean on behalf of the Commonwealth, and along with me at council table is Assistant District Attorney John C. Mooney, the trial prosecutor. Your Honors, I heard three different bases. The manner in which the search was conducted, an allegation that there was no probable cause to conduct a strip search, and then third, excessive frisking, apparently. I'll just take them in order unless you wanted to start somewhere in particular. The manner in which the search here was conducted, it's always measured by reasonableness. In Morales...
And you mean that it was done in public, right?
Well, that's a factor, correct, Your Honor. Morales points to the fact that reasonableness is always a balance of the need versus the intrusiveness. So here, the fact that it wasn't done in public, the need for that is, as Justice Brennan pointed out, what could happen during transit to avoid a potential problem during transit. We are talking about a potentially very dangerous...
Right, but we have a situation where the, better or for worse, the SJC has set some standard, and here in this case is different. In that case, it was at night. They went between two buildings. This case is in the middle of the day on a public street with a passerby on one side, a school bus going by on the other side, and just to make it even more fun, a preschool is the house next door.
Well, Your Honor, I'm going to disagree a bit with your characterization of Morales. I mean, Morales was they took him to essentially an alleyway between two buildings, pulled his waistband back and illuminated the area with the flashlight. And the SJC also noted that every resident on either side could then see down to the highlighted area. So while it did occur in public in Morales, it occurred under those set of facts. Here, you got to watch the body-worn camera to see how it actually occurred.
We have.
So this was... yes, they did move, Officer O'Toole did move his last layer of clothing in order to reach his hand in and retrieve the item. But as the body-worn camera shows, Officer O'Toole was the only person that was able to see anything at all.
Right, but the case law says that doesn't matter.
Well, I respectfully disagree with you there, Honor. All the case law says there is that doesn't matter for purposes of determining whether it's a strip search or not. It has nothing to do with the reasonableness of it. And I would actually point you to the second factor that the Morales court pointed out in assessing the reasonableness was how many people can see. Only the investigating officer or others? They're not talking about how many people might happen to walk by and see that there's something happening, but how many people can see the nature of what we're talking about.
Assume for the moment that I accept your argument that the police actually acted pretty reasonably, their tone, their interaction, the tenor, they shield him as best they can, and so put Morales out of it. And assume even further that I agree with Chief Justice Gantz on Amato and the dissent and on that. That's not what Amato says, though, the majority. So distinguish Amato for me, if you would, and tell me how in the world we get to where you need us to be with Amato sitting out there, if you will, hovering over us.
Well, Amato was decided on two grounds. The first was that the pat frisk exceeded the scope of a permissible pat frisk. Amato was a stop.
So we don't need that one. We're good there.
Set aside.
Yep. Get me to the second part,
yes, Your Honor.
So evolving into probable cause, and I don't see even one difference between that case and this case. Minor motor vehicle. Go ahead. I'll let you
Your Honor,
go.
I would start with Amato didn't have there was no blocking of the frisk in Amato. And while in Amato he did twice claim he didn't have anything when he did, so he did lie, so there is some consciousness of guilt. The other distinguishing factor here is that not only did he claim he didn't have anything, he falsely claimed the officer was grabbing his testicle when he was grabbing the contraband. So we have an elevated level of consciousness of guilt. So the
How do
two-
we, I mean, we have no idea. The officer was definitely trying to get the contraband, but, you know, what he was actually feeling, none of us, I mean, clearly he was feeling contraband, but I mean, he could have also been feeling the other things that were there.
Yes, Your Honor. However, the officer testified that what he felt was a foreign object. It was not anatomy, and it was golf ball size. Turned out to be 35 grams of cocaine. I think it was 16 grams of fentanyl, trafficking weight of both, in an area where he had a prior experience discovering narcotics in a
Right,
field
but Armato
consistent.
also said that he had prior experience, and I mean, obviously, if the standard were then this was drugs, but that's not what the Supreme Judicial Court has said the standard is.
Correct, Your Honor, but here we have blocking behavior, which started almost immediately. If you watch the video, the exit order occurred.
Saying the defendant blocking the police, not the police shielding. You're saying that sort of blocking. Is that just unclear?
Yes, blocking the frisk from occurring. It happens almost immediately. At 3:46, the defendant exited the driver's seat. At 3:48, Officer O'Toole initiated the frisk. At 3:50, the defendant has already got his hands swiping to try to prevent the officer from doing the frisk.
What do you say to your counsel's argument that that's kind of a natural reaction when someone's reaching in your crotch area?
Well, respectfully, Your Honor, if you watch the video, you'll see that his hands are out to allow the frisk to occur. As soon as the frisk immediately goes to where he knows he has the contraband secreted, he immediately tries to swipe the hand away and block
Well,
it.
yeah, but when you look, I mean, that was wow, in terms of the police officer just, I mean, this did not start at the guy's top and go down. The police officer just went like a punch in. I mean, it was a grab of really most.
Yes, Your Honor, the officer, based on his 3.5 years of experience and his training and his repeatedly
I know, and the
discovering
duh
drugs there.
factor, of course, that's what was, but this was not like, let me feel your whole body down. This way, I mean, he just immediately went in for the crotch area. I don't, you know.
A pat frisk can start anywhere, Your Honor. And this was not just a pat frisk, this was a search incident to arrest. So it was already authorized to be more intrusive than a traditional Terry stop, as was seen in Amato, which was just a frisk under Terry for weapons for officer safety. So
At
of
this
course,
point, are you conceding this was a strip search or not?
we're not conceding that, Your Honor.
Okay,
I
so
can-
the defendant says that you didn't argue that issue one way or the other to the motion judge, but you did concede it in the petition, in the opposition or response to the petition for application for the interlocutory appeal, that you said technically it was a strip search.
Well, fine, Your Honor. If the court's going to conclude that it was a strip search, the court's going to conclude that. But what we want to make clear is that when the SJC initially held in Morales that the opinion that talked about moving the last layer of clothing, the initial portion of that sentence began with the word may. In subsequent cases, in a couple of subsequent cases, that initial portion of the sentence has been dropped. So the defense argues that moving the last layer of clothing automatically equals strip search. That's not what Morales said. Morales said it may equal a strip search. They used that word consciously. They could have said is. They chose may. And they chose that because of this set of facts, where it's not exposed to anyone else and the officer has to reach his hand in to recover the item. That's why they used the word may. In Vic, the appeals court carried the full quote and used the word may. However, in Giannis, most recent sort of case from the SJC, they dropped the beginning of the Morales quote and the word may, although nobody was contesting in Giannis whether it was a strip search or not.
So is your position then that the officer moving the defendant's clothing was actually less intrusive because then he's avoiding touching the defendant's genitals instead of by determining where exactly the object was, or is it something else you're saying about that?
Basically, Your Honor. Basically, Your Honor. When we're talking about a strip search, the concept is that the person is then fully naked and people are fully observing their private areas, including their genitals.
Well, but that's, I mean, Morales just requires that the intimate areas be viewed, exposed, or displayed, not that they be viewed by the public.
A strip search also may occur, is how that sentence begins. May occur when these following things happen. They left that caveat out for this set of facts. But I understand the court may not go with me on that. We just want to make sure that that argument is preserved in case we find ourselves at the next level and we can clarify Morales and what the SJC actually meant. So if this court determines that it was a strip search, there was probable cause here. This case is closer to Vic than it is to Amato. We just don't have all of the things that happened after the scene in Vic. So as in Vic, there was plain feel with experience with drugs. And Vic was also a search incident to arrest. The defendant tightened his muscles and pulled away when the officer touched the object. Basically the same thing that happened here, trying to prevent the frisk from occurring. And then the defendant in Vic resisted, ultimately forcefully, such that he had to be cuffed. Here, the defendant had to be relocated to the back of the car, and they had to repeatedly instruct him to stop blocking and stop pulling away.
Do you cite that case in your brief?
Vic, I believe so, Your Honor. I've certainly cited it within either mine or the defendant's brief. I don't have the pinpoint here with me. I'll look, Your Honor, and if I haven't, I'll provide a 16L.
Okay.
Is it the same Vic that's on the double jeopardy issue?
I'm sorry, Your Honor?
Is it the same Vic that has the double jeopardy issue, or is it a different Vic?
I'm not sure I understand how a double jeopardy issue.
Is the case, there's a famous Vic case that has to do with double jeopardy. Is this the same case?
No, Your Honor.
Okay.
No, Your Honor. This was a search incident to arrest.
If you could, I don't see it cited in either brief unless I'm missing, but go ahead, I'm sorry. Go ahead.
My apologies, Your Honor.
So,
Well, then I'll move away from Vic for the purposes of the argument.
I have a fondness for cases with Vic in the name, but the defendant argues that at no point either on scene or later in the testimony is it suggested that the object the officer thought he could feel was a weapon. Do you agree with that? Is that correct?
Correct, Your Honor.
Okay.
Correct, Your Honor. But what
So
we
what,
have,
it seems to me like, so yes, the defendant is saying that he's denying that there's anything there. He's saying those are my, that's my genitals. Why doesn't the officer say, look, you and I both know what's there. Why don't you grab it out for yourself, or I'm going to do it. I'm going to take you to the station and do it.
he could have, Your Honor, he could have. But again, transporting him to the station involves additional risk of what happens with that material during the transport. So this really needs to be addressed on scene.
Are they allowed to keep him in handcuffs in the back of the cruiser?
Yes, Your Honor.
Are they allowed to have an officer sitting next to him?
Yes, that's all permissible. But I would point out that it might have been Amato. No, it wasn't Amato. Again, it's again Vic, but while he's being transported in Vic, he prevented the frisk from adequately occurring on the scene, and they transported him in cuffs, and during the transport, he was attempting to obtain the items. So that creates a real risk or danger for the Commonwealth to allow a defendant in the back seat of a cruiser being transported with potentially the ability to access the materials.
I found your Vic. It's 90 Mass App 622, 2016 case. It's not the double jeopardy Vic.
You try to distinguish Armato in your brief. You say the arresting officer knew the object was not a weapon, but, well, let me try that again. You say here the officer was relying on his experience, but Armato says the same thing, that the officer knew the object was not a weapon, but only suspected it was contraband based on his experience finding drugs concealed in the genital area. So why is this case different?
Two reasons. One is the blocking behavior that we see here that you can see right at the beginning of the frisk and then throughout. If you listen to the audio until 4:50, you'll hear the Officer O'Toole still instructing the defendant, stop pulling away, stop preventing me from doing this. So throughout, he's trying to thwart it, trying to prevent it from happening.
Significance of that is what?
I'm sorry, Your Honor?
The significance of that, from your perspective, is what?
Consciousness of guilt, Your Honor.
So with that, you say, adds to the probable cause recipe?
Absolutely, Your Honor. Absolutely. What we're looking to establish here is that the existence, what's required for the strip search is probable cause to believe that there is, one of the things can be contraband in a location that can't be secured in a regular search incident. So here he has to do a little bit of additional checking to make sure that he can't retrieve that item in a regular search incident. This is going to require moving the last layer of clothing to retrieve it. So that's, again, the difference between a Terry stop or a search incident here, and that the full extent of the probable cause can develop during the search incident, which is what happened here.
So why is the search here more private than what happened in Armato?
In Amato, he was moved to an area where apartment buildings were on both sides above him, and the area was illuminated as they pulled the waistband back. And the SJC noted in Amato that meant residents on both sides could see into that area, see it happening. Here, the officer did the best he could at the scene, blocking one side of the defendant's body himself, his partner blocking the other side of the defendant's body, and simply pulled the last layer of clothing out, reached down and retrieved the item. He tried to accomplish this also using the door of the driver's side of the vehicle, but was unable to accomplish the frisk there because of the defendant's efforts to prevent it from happening, which is why he had to relocate him to the back. So under the facts of what was happening here, Officer O'Toole behaved reasonably. He did the best he could to try to make this event as private as possible there at the scene. without incurring the additional risk of transporting him with whatever this item was likely
If we're
contraband.
looking at, I think you said we need to look at the reasonableness of what happened here, right?
Correct, Your Honor.
So why couldn't they just bring a wagon or an ambulance?
They didn't have a wagon there unseen. What they had was 3 officers and a 4th arriving. So they did the best they could to shield
How
him with
many
it.
police cars did they have unseen at that point?
2, Your Honor.
Okay.
So they did the best they could to shield him with the resources that they had there available. And again, the question is just reasonableness, the need versus the intrusiveness.
Any significance at all? Am I wrong that he had 2 pairs of sweatpants on?
My understanding was 3 layers total.
3 layers.
So two layers of pants. The outer layer appears to be sweatpants from the body worn, and then
But there was no testimony, no evidence about in what layer this packet was found? Whether
my
it was against
understanding,
the skin versus under the underwear versus under the first layer of clothing? I just don't remember.
my understanding has always been it was against the skin. But he did, again, part of the reason why the search incident had to be like more thorough than you would see in a standard frisk is the 3 layers. He has to try to identify where the item is and if he can retrieve it without doing what may technically qualify as a strip search. If there are no further questions, Officer O'Toole conducted this search in the most reasonable manner that he could under the circumstances that presented him. Thank you.
Thank you both. Case is submitted. What's the next case? Is the other case? What do you think about going for a 4th? I won't give any warning then. Right. Okay. So calling the next case, Commonwealth versus Braun, B-R-A-U-N, 2020 P618.
Yes. Good morning, Your Honors. Attorney Jason Howard on behalf of Mr. Braun. I'm here to appealing both Mr. Braun's underlying rape conviction on grounds which I claim was the inadmissibility of the DNA testimony and evidence that went before the jury. And I'm also here challenging my client's habitual offender conviction at bench trial about a week later on grounds that the documents submitted did not sufficiently prove my client's identity, and also a claim regarding the judicial notice taken by the judge at the beginning of the trial. Regarding the underlying rape conviction, Your Honor, Your Honors, I focus specifically on that DNA evidence, which I suggest was not authenticated. It was not supported by an accurate chain of custody, and its admissibility or admission violated both the Sixth Amendment right of confrontation as well as the Commonwealth's more broad protections regarding.
So am I understanding your argument correctly that the Commonwealth basically had a burden of proof to establish a chain of custody for the DNA evidence to come in, and it just failed to establish the chain of custody?
Yes, in so many words, Your Honor. Consistent with Commonwealth v. Jones, what happened in this case, as I know Your Honors are familiar with, is once the complaining witness, her testimony ends at going to the hospital and being examined with no indication of what exactly was examined, and the Commonwealth never presented the sane nurse or anyone from the hospital, for that matter, to give any clarity in terms of what examination was performed, because then
Well, so if I'm just for ease of reference, if the hospital records say tests 1, 2, 3, or swabs 1, 2, 3, and 4 were taken, and then the DNA people say, I did tests on swabs 1, 2, 3, and 4, but there's no link between those. That's your concern.
Yes, precisely, even conceded in the Commonwealth brief, as explained by Commonwealth versus Jones. Commonwealth versus Jones is very similar to my case, with the exception being defense counsel had objected in Jones and my defense counsel did not. But with respect to Commonwealth versus Jones, the issue was the chemists at the state laboratory testified regarding swabs that they had received from the hospital and where those swabs were taken. In response, Commonwealth argument in prosecution argument in the Jones case was, well, we admitted the records and that's good enough to establish.
Am I wrong? Isn't Jones, wasn't part of Jones that the state police chemist testified about what Cellmark did? Isn't in Jones, is that the wrong case? I thought in that case they...
That is...
That's not, okay, thank you.
Yeah, there was
Yep, all right. I got that one too. Okay.
Right.
And why is this not a, in terms of chain of custody, why is it not a weight versus as admissibility
Sure.
circumstance?
It is not a weight versus admissibility because it's As much as it is chain of custody or authenticity in terms of where the swabs came from, it's actually an issue of admission of hearsay, Your Honor, because Ms. Menendez, who was the state chemist, testifies that she receives these swabs from the laboratory and explains where the swabs were taken when Ms. Menendez from the state laboratory has absolutely no connection to the hospital where the swabs were taken. She was not present when the swabs were taken, therefore she has no personal knowledge of where the swabs were taken. Moreover, in the context of my case, she has no personal knowledge that the swabs are even taken from the complaining witness. So it goes to the fact that the trial court at the trial stage permitted hearsay evidence. Ms. Menendez did not know on personal knowledge or
Okay, but that was, you're saying the hearsay evidence is the medical record which was entered as an exhibit, presumably as an exception to the hearsay rule?
the hearsay evidence is where specifically the swabs were taken from
Okay.
the person who was examined. There was no evidence from anyone from the hospital or with personal knowledge of the evidence collection conducted at the hospital that the complaining witness had swabs taken from her body and where those swabs were taken.
I'm sorry, that's,
But don't the hospital records say the swabs were taken from this person in areas 1, 2, 3, and 4?
The hospital records say that swabs were taken. However,
But they say particular types of swabs were taken.
descriptive types, external, vaginal, perianal.
Right.
There's no description of what those swabs, what that actually means. And it's Ms. Menendez who provides additional evidence through her testimony about where specific to the complaining witness's body those swabs were taken.
does she
And
do it specific to the complaining witness's body, or does she do it just specific to a body more generally, that this is where a perianal swab is taken from, this is where, and,
Right. She did not say, right, Ms. Menendez did not say that they were specifically taken from this area of Sally Smith, but she did say that these swabbings were taken from a specific area, and there's no evidence within Ms. Menendez, Ms. Dugan, that they came from the complaining witness. No one was, whether it's Ms. Menendez or the DNA analyst.
other than the medical records pertaining to this particular person, having her name on it and whatever other identifying information about her.
The medical, yes,
Okay.
the medical records absolutely were admitted. I can't get around that without objection by defense counsel, and perhaps
Well,
he
and-
should have objected.
This inventory list is also present in Jones. The inventory list that says where the swabs came from, that's also in Jones.
Right, and it was not found by the SJC to be persuasive to remove the hearsay and authenticity
Right.
issues that were present in that case, because you have, the state chemist was merely parroting, regurgitating, what was her belief of where they were taken.
Now, speaking for myself only, I find this case indistinguishable from Jones. Jones gives a roadmap of how the Commonwealth is supposed to do this, except it's indistinguishable except for two things. One of them is that there is a greater probability, it is a 1 in 1,000 as opposed to 1 in 8 here, so it's more prejudicial, or more probative rather, not prejudicial, it's more probative of guilt. But in Jones there was an objection, and here there's no objection. And if there'd been, the reason we asked for an objection is because it gives an opportunity for the court or the Commonwealth to do it right. I mean, if there'd been an objection, couldn't the Commonwealth have easily brought in a nurse or somebody familiar with the hospital, the way a sane kid is made, to fill in that gap?
Certainly, there was no objection. And my take on it, there clearly should have been an objection. This was, in my opinion, based on my read of Jones, Tassone, Grenadier, Barboza, et cetera, it was absolutely required to have someone with personal knowledge establish a link between an examination performed of the complaining witness and what testing was performed on her and what those results were. It appears to me that trial counsel had begun a strategy of conceding intercourse. And this is inference from the record because there was no objection. After the first day of trial, there is, as I argue with respect to closing arguments, there was a lot of inconsistency regarding the two civilians, the alleged victim as well as her mother, about the happening of the incident.
So you are conceding pretty clear in the opening that this started as a consent?
Yeah, I mean, yes.
Right,
yes,
straight up consent, not, right.
It is what, yes, I mean, that's what the defense counsel argued in opening or suggested in opening. And my point regarding the changing the horse along the way is that the civilians testified on the first day, and inferentially things changed regarding how he was going to approach the case. On the second day is when the experts are coming in regarding the admissibility, or, regarding DNA testing, swabbings, et cetera. Regarding the standard of review for substantial miscarriage, I don't think there's any trial strategy in not objecting to this information. I suggest it in terms of that four-prong analysis of substantial risk of miscarriage of justice. There was no reason, if there's a change in strategy, which it clearly was, you look at the opening, compare it to the closing, things changed in his mind.
Is your perspective that the closing was a straight-up credibility, it never happened? As I read it, it looked a little bit like a, it was consensual, but if it wasn't, it really didn't happen.
Yeah,
Kind of.
Yeah, the closing more strenuously, in my estimation, given his objection, right? So, for example, at the conclusion of the prosecutor's argument, he goes right to the DNA, the aspect of the prosecutor's closing argument regarding the DNA. There was a potential, my client, Mr. Braun, was not matched, quote unquote matched, one within 25 million quintillion. It was, hey, 1 in 8 of a male paternal lineage on the Y chromosome. And the prosecutor had indicated to the jury in an argument that, well, he's talked a lot in his closing, defense counsel, about credibility. Well, what you can't contest is that DNA thing that matches Mr. Olivio Braun. Well, it didn't match Mr. Olivio Braun, as we just talked about, the 1 in 8 paternal line. Also, there was a minor contributor to the profile as well, as borne out by the evidence. And so he objects to the judge, and he says, hey, that's not what the testimony was regarding the DNA. So his antennae are up about the DNA. And then he was asked to propose a curative instruction, which he was unable to do. But in my opinion, he had objected. It would have been more proper on the judge to fashion a curative instruction to kind of set the record straight regarding how the jury was to consider the DNA that they received, that I suggest under Jones they should have never received in the first place. But yeah, there was a change in his strategy. It seems to be clear based on the transcript.
Can I ask a question about the habitual offender?
Yes.
Part of it, before we get a little more time. Your client's photograph was in the DOC records, right?
There is a photograph in the DOC records.
Okay, so there's a photograph. You're right. I stand corrected. The person who was convicted of the 2 offenses had a photograph in the DOC records.
Yes.
Could that alone, if the fact finder is looking at the photo and looking at the human being, be enough to be proof beyond a reasonable doubt?
I don't know, Your Honor. I respectfully say no. I've seen the photograph case that I'm aware of, I believe is, if it's either Olivio or DeSant, but there is additional information tying the defendant on trial to the documents. If the court were to accept the premise that the date of birth of Mr. Olivio Braun before the court should not have been judicially noticed, then we have, with regards to that subsequent trial, a person seated at defense counsel. And the only evidence regarding the records of that person is the picture and some descriptive qualities, but we don't know in this record, there's no proof at all regarding what this gentleman's date of birth is, what his physical characteristics are, what I think it had to do with glasses, etc. And perhaps it's an aspect of sufficiency of proof, which I raised. It's about a 1-inch by 1-inch photograph of the person depicted in the DOC records. The photograph cases that I'm aware of which have additional information, the arresting officer prior to the conviction. For example, Olivio, we arrested him in Springfield for drug charges, filed the charges, drug charges in Springfield District Court. We have the court documents that correspond to the gentleman's addresses, history of addresses, date of birth, and descriptive characteristics. We don't have this in this case, and not to be facetious, but is there a doppelganger? Is there a twin? There's no one to put the defendant in the chair as the gentleman captured in that photograph. And I will also point out that the photograph cases customarily involve that RMV records, which has that, and I guess this is beyond the record, has that nice digital image of the person, individual who appears for the RMV photograph. It's usually RMV documents that include the RMV image of the putative person, as well as history, background, driving background, etc. We don't have that in this case. We have different spellings of the name within the documents, whether it's an Olivio C. Braun versus an Olivio Braun. We have information regarding convictions, but no one puts my client at the DOC relative to those records, and that's where I come down on that, Your Honor. I think the photograph in and of itself, and no indication within the record that there was any finding by the court, not that he has to make any, but any findings by the court that he looks like the person in this picture. I mean, that it just was never even touched, never even addressed, never even brought to anyone's attention. He was a snowflake, just an individual before the court, no information regarding that individual.
Isn't there an officer who testifies that he was arrested for those other crimes?
No, respectfully, no, Your Honor. It was Detective Bell who said, I arrested the person on trial on an outstanding warrant for a domestic A&B out of the Brockton District Court. The documents that are introduced are indictments out of the Brockton Superior Court. So this doesn't even comport with Commonwealth versus Olivio, where the gentleman who was arrested, where charges were filed in the Springfield District Court, and then the court dockets from the Springfield District Court for the arrested offenses were introduced. We have Detective Bell said, I arrested him, doesn't say his date of birth, any biographical information regarding the individual he arrested at booking. Charges were on a warrant out of Brockton District Court. Nothing that warrant was for assault and battery, dangerous weapon against the named individual. Nothing about the date of offense. Nothing about that case had been indicted, and I had sat through the trial and saw the gentleman convicted. So respectfully, no, and I always go so fast.
Yeah. Any other questions? Okay. Thank you very much.
Thank
we'll
you.
hear from the Commonwealth. And before the Commonwealth starts, I just want to, our counsel for the fourth case here, the Kenn versus EASCARE?
I got one over here.
One. Okay, because we'll probably, we might take it, we usually take a break after 3, but since we're going pretty quick, it seems fast to me too. We're going to hear that case before the break, so stick around. Sorry to interrupt.
Thank you, Your Honor. If it pleases the Court, Arne Hansen for the Commonwealth. With respect to the judicial notice issue and the habitual offender conviction, I'd like to start with the records that were put in. I have in front of me, and it's part of the defendant's record appendix. It's page 80 as well as 81. It's the defendant's biographical data in the Department of Corrections record, which were submitted at the subsequent trial. The first point, the first line is the defendant's name, and then it gives his date of birth as the second point. Then there's also a photo of the defendant. Then,
Can I actually assume, I'm going to jump to it because to me, I get the DOC record, that identifies a particular person. How do you tie that to the person who just was on trial? Your proposition is either A judge can take judicial notice of testimony in a different trial?
no, that would be incorrect. Coney
Okay.
addresses that. So you're not allowed to take judicial notice, but we have all of these records to establish that this individual is in fact the same individual. We had to.
How does the judge know that the person seated in front of him had a particular date of birth? It's not on the indictments as opposed to in a district court complaint, you have a date of birth, right? So how does he know the date of birth of the person who's sitting in the chair?
The date of birth is on the Department of Corrections records, which are prima facie evidence of prior
For a
convictions.
person who was indicted and convicted 10 years ago and did a 3 to 5 on one and I don't remember on the other, right? For a person.
It has, so they have the same date of birth, they have the same name.
Same as what? As each other?
As the defendant, yes.
And what about the person who's sitting in the chair? How does the fact finder know that person's date of birth?
It was introduced in his criminal records.
Which, didn't BOP, with the right border probation record, not put in?
No, the Department of Corrections
Right.
records have that date of
So
birth.
again, maybe we're going in circles, but that Department of Correction record tells the fact finder that a person by a particular name with a date of birth was convicted of certain crimes and sentenced. Great. How does the fact finder then tie that to the person who's sitting in the courtroom. What information is there at all about the person who is sitting in the defendant's chair? I just don't see it.
I understand what Your Honor is saying. I would agree that the only evidence of his date of birth was the judicial notice. Outside of the date of birth, there was still substantial evidence linking the defendant to this case.
And just so we're clear on that, I think you make an argument about the colloquy.
That is true.
You're not suggesting that the judge in a separate procedural conversation who gets information can then take that information and port it into a trial as a fact finder.
No, the argument here would be it's part of a general picture of whether or not this is the same individual and whether there's any doubt as to that.
And again, not to be difficult, but how do you have a general picture if you don't have evidence? Because that's not evidence, right? The colloquy that he had about you're 35 years old or whatever the age was, that's not evidence in the trial, right?
That's correct.
Because it could have been a totally different judge. Some judge does the waiver, another judge does the trial, or a jury for that matter. So that's out. And then we agree that judicial notice cannot be taken of something to which somebody testified in a separate trial, right?
Correct.
So that's out.
Yes.
So what's left?
We have his Department of Corrections records, which have his name, photograph, as well as a general description of the individual. The inmate's characteristics provides a detailed list of the physical characteristics of the defendant, which the judge would have been in a position to evaluate.
Okay, so is it your position that that alone, the physical characteristics described in the photograph is sufficient for a fact finder to find beyond reasonable doubt that the person in the courtroom is the person in the photo?
Correct. And then there's also...
You make that argument in your brief?
I believe it was included in general that there was more than sufficient evidence. I think the standard here is that you have to have more than just a name. And the Commonwealth certainly had that here, where you had a physical description in the records, as well as a photograph, as well as his addresses. So the Department of Corrections...
What's the Commonwealth's burden of proof at the trial on this issue? Is it beyond a reasonable doubt or just a preponderance?
It would be beyond a reasonable doubt.
Okay.
So with respect to...
And then we look at it in the light most favorable to the Commonwealth, obviously, right?
Right.
Like, as a required finding. All right.
And we're looking at it under a substantial risk analysis.
With respect to that, there's also the address history, which is what the prior cases state can be analyzed. So the certified dockets that were also introduced had prior addresses of the defendant, which could be used to link him to that case as well. Both of those addresses.
And I'm just not trying to be difficult with you, but again, were there any dockets, was there any biographical information, was there anything at all presented about the person in the courtroom on the indictment for which he had just been convicted or anything else?
Not specifically, no. The dockets are linked to the defendant by the fact that the Department of Corrections records also list his convictions, and those match exactly the date of offense, date of disposition, the punishment match exactly to the certified dockets which were introduced.
Okay.
Now, with respect to the DNA issue, I would point out for the court that the victim did testify that her vagina was swabbed. I cited that in my facts section. That would be the first transcript, page 123. I'm relying on my brief. I don't have the transcript in front of me. But
Is that different from Jones?
Jones, from my recollection, it doesn't specifically address whether or not the victim testified to that or not, but it does have a head note that states that you would expect either the victim or the person that did the swab to testify as to that. So it appears that in Jones, that was absent. Here, the victim did testify that her vagina was swabbed, and that's page 123 on the transcript.
Was it the Commonwealth's burden to establish the chain of custody for the swabs that were taken?
That is correct.
Did the Commonwealth do that?
Yes. So we have the victim's testimony that her vagina was swabbed. Then we introduced the medical records, which included the rape kit. Those were agreed to, wasn't objected to. They were redacted, so all the mentions of sexual assault were removed from those records prior to being put into the jury. As part of the rape kit, they show that the analysis was done, and it provides an inventory of which parts of the victim's body were swabbed. This was introduced into evidence. So with respect to what the actual experts testified to, Menendez never actually testified to that this came from this specific victim. She testified to her training and experience as to what a vaginal swab is, what an outside genitalia swab is, what a control swab is. She never actually said that these tests or these swabs came from this specific victim. She just is talking about what she does for a living. She says, I conducted this test on this sample, which was labeled this, and this is what I found. So she says that she was found no saliva on the inside the vagina swab, but on the external genitalia swab, she did find male saliva. And to reinforce that issue, the second expert, Ms. Drugan, explicitly testified that she knows nothing about where these tests come from. She says, the only thing I know is what's in my case file. And the jury is left with that. So if you look at the Grinder court decision, essentially the jury can evaluate where there is no testimony about how the evidence was collected. The jury can add whatever weight it sees regarding the admission of that into evidence. So if they say, hey, we didn't hear from the expert who actually, or the nurse who actually did the swabs, how do we know they were done correctly? That's something they can consider. But I think what's important to note here is that the defendant never challenged this. In fact, he stipulated to, the defense counsel was going to stipulate to this, and I cite the exact site in my brief, but for it appears that the defendant may have been a difficult client and didn't allow him to
Or
stipulate.
a better
this.
lawyer than his lawyer was.
That is also an interpretation.
I mean, I do have a concern, because you do quote this, that the defense counsel was saying he didn't have a problem with it, but that doesn't make it okay. He didn't stipulate, right?
Correct. Now, with respect to Jones, there are substantial differences between Jones and our case. The procedure follows very closely, but how that evidence was treated at trial is very divergent. Now, in Jones, the defense was consent and lack of penetration. Here, the defense was Commonwealth didn't meet its burden. It appears the defense shifted. The defense counsel initially stated it was consent, and then shifted strategies, attacking the credibility of the evidence and attacking the weight of the evidence, or the forensic evidence that was admitted. But in Jones, we have a DNA test that positively linked the defendant, Jones, to the saliva found inside of that victim. And there was a 1 in 1,000 chance that DNA came from somebody, or from a person at random from the population. And therefore, Jones really didn't have any options. The only thing, the DNA was a full match, full profile, very unlikely that it was going to come from somebody else. So Jones had to attack the methodology, and he was unable to do so because the person who testified, or the person who took that sample, did not testify at trial. And that's what deprived Jones of a fair trial. And he vehemently objected to the inclusion of this. And then the Commonwealth then said, give us some time, we'll get the nurse in here. And the judge said, no, that's not necessary, we'll move forward as is. Here, that didn't happen. The defendant had no issues with the methodology.
Well,
And
how
instead
could you say
attacked-
that when they didn't stipulate to it?
Because they
it's-
never objected to the admission of this testimony. And I would also argue that there's factual differences between how the experts testified in this case versus how they testified in Jones. In Jones, they testified as if they had done the swabs and knew what they, had intimate knowledge of how those swabs were done despite not working for that hospital or being in the room when they were done. Here, they testified as to their general knowledge and essentially what the labels were on their kits and then the analysis they did on those specific samples.
So in this case, weren't the DNA results important to corroborate that the defendant had in fact put his mouth on the victim's vagina?
Yes and no. So with this type of rape, you would have to prove penetration, and what we found here was saliva on the outside of the victim, not on the inside, and that is the largest distinction between Jones and
But that takes it out of a realm of he said, she said, when there's actually some evidence of what she said being correct.
It certainly bolstered the victim's position, but in Jones, it completely refuted his defense. The jury was still in a position to assign whatever weight they wanted to that evidence, where it was only a 1 in 8, there was a 1 in 8 chance that it could have come from anyone else in the population. And I looked briefly in this room. I think there's about 15 males in this room. That means 2 of us in this room could potentially have that same DNA. Where the odds are 1 in 1,000, I would argue that there might be only one person in this entire block that would match that profile. So that certainly makes a very large difference in the weight that was assigned. And ultimately, if we look at the prosecutor's closing argument, she's saying, yes, there's male DNA on there, but she's minimizing the statistical value of that DNA evidence by saying, it doesn't matter if it's 1 in 8 or 1 in a million. And she's going back to the jury and asking the jury to believe the victim's testimony, who says, this is the person that woke me up in the middle of the night, and I woke up with his tongue inside my vagina. And she's asking the jury to credit that. This was not a case where the
Yes and no. I mean, I agree with you about the numbers was rhetorical, but she also said this came from him,
Correct.
which
Which was a misstatement of the evidence. You're allowed to make reasonable inferences, but what would have been a more accurate statement is there was a partial profile that the defendant could not have been excluded from. And she's not that far off. But then the next statement she makes immediately minimizes the importance of that evidence by assigning hypothetical statistical values and saying, no matter what this value is, I'm just asking you to believe the victim.
although again, if the evidence was even better, I mean, than what I have, then it would be, that wouldn't matter.
Right. Does the court have any additional questions?
Hearing none.
Thank you.
Thank you
I
both.
rest on my
Interesting case. Well, it is submitted.
Thank you.
And go ahead. So we'll be hearing the next case. And after this fourth case, we will take our customary 15-minute break. So, but the fourth case is 22P1017, Kenn versus EASCARE LLC.
If the court's ready.
Go ahead.
Okay. Thank you, Your Honors. Raven Moslinger for the appellant. May it please the court.
I'm sorry. Could you get closer? Yeah.
Sure. Raven Moslinger for the appellant. May it please the court.
Moslinger is how you say it?
Moslinger.
Attorney
Yes,
Moslinger.
Your Honor. Thank
Okay,
you.
thank you.
The question raised by this appeal is, when does a plaintiff have a right to sue under a statute? And the simple answer is when the statute says so. But to put it more eloquently and in this court's own words, when a statute confers standing in relation to particular subject matter, that statute, rather than more general ideas about standing, govern who may initiate legal action in relation to the subject matter. And the fundamental error that the trial court committed here was looking at general ideas about standing rather than just the text of the statute to determine whether Ms. Kenn had standing to sue under the Fair Credit Reporting Act.
So I had a question that I just didn't understand from the back and forth between the two briefs. Are you arguing that your client was injured because the employer did not have a valid authorization to obtain her consumer report, and yet the employer obtained her consumer report?
Well, there's two separate violations. One is the failure to provide a standalone disclosure.
Yeah, that I got. That's clear.
And then the second argument, which has been adopted by some courts, is that the failure to provide a lawful disclosure results in an illegal authorization.
And are you arguing that one?
Both.
Okay.
Both. And Your Honor, what I will note is at the trial court level, it did not appear that EASCARE actually objected to the idea that they violated the FCRA, as the trial court noted in its decision. Instead, they're claiming that the plaintiff lacks standing to bring suit for noncompliance with the statute.
Can I just ask you an evidentiary question? The disclosure is on page A31 and A32, right? And I mean, and I can't tell if it's the front and back of a piece of paper, because the A31 looks like a standalone disclosure with an authorization.
Right. Now, the issue, Your Honor, is that when you include extraneous information within that disclosure, you have violated the FCRA. For example, within that disclosure, there's exculpatory language. There's a release of claims.
Well, no, that's not on A31. That's on A32.
Right. Well, sure. So I guess it doesn't need to be on one page. It can be a two-page document. And what we received was, as far as getting the personnel record from the plaintiff, was, I believe, a two-page document.
Right, but I think the issue is can you have the release that complies with the Fair Credit Reporting Act as one page, and then as an entirely separate document, then they have the release and the waiver? Is that okay?
No, if it's being done in conjunction with the disclosure requirements, I don't think that any court would permit that to go forward. And this was within one document, maybe 2 pages, but it's within one document, the disclosure. And at least at the pleading stage, which is where we were at, this court can take that reasonable inference to the bank and.
So in terms of the pleading stage, so are you alleging injury or not?
Well, we're alleging noncompliance with the statute, which is injury enough to bring suit. So what
But there's no individualized injury that.
we don't need one. I would say that within the complaint, we have alleged a separate and apart and injury, but there isn't one that's.
What is that? What is that? In some informational or privacy injury that was violated? I didn't see it
Sure, it's an unlawful invasion of privacy because Congress has set out the way in which you can invade someone's privacy and engage in these sorts of invasive background reports, and they did not do so lawfully. So that's an invasion.
But is there any instance of your client actually having privacy invaded or information obtained in some harmful way?
No. And Your Honor,
but that goes back to the very first question I asked you, which is if they obtain a credit report about her, a consumer report about her, without her lawful authorization, you're claiming that happened, right?
Yes.
And you're claiming that was an injury?
Yes.
Okay.
But I don't want to get
Don't snatch victory out of the, or defeat out of the jaws
Fair
of
enough,
victory
Your
there,
Honor.
because you really seem like you're trying to.
Fair enough, Your Honor.
Okay.
But what I will point to is this court's authority and the authority from the SJC, which says that when you have when you're deciding standing under the statute, we're not looking at general principles of standing. We're not looking at, does this person have a particularized injury separate and apart from the legal violation that they're complaining about. You just look at the text of the statute. And if you look at the private right of action provision within the FCRA, this is what it says. Any person, and a person is defined as, can be a corporation, so the employer, who willfully fails to comply with any requirement imposed under this subchapter, that includes the disclosure violations, with respect to any consumer, which is an employee or any person, is liable to that consumer in an amount equal to the sum of any actual damages or damages of not less than $100 and not more than $1,000. So, and also provides for punitive damages. And as the Seventh Circuit has described this, it means that there are modest statutory damages without having to demonstrate injury separate and apart from the legal violation.
There's a Seventh Circuit case that says that.
There is.
How was there Article 3 standing on that?
They didn't address it. That was they were just describing the statute in the context of approving a class action settlement. But that's the thing. Article 3 doesn't apply here.
Right, I understand.
Right?
Because you don't cite any cases, any state cases where they've allowed this cause of action.
They have not, Your Honor. This just hasn't come up within state court jurisprudence. But I would point the court to the Supreme Court of the United States decision and the TransUnion decision that is within our brief. And in there, Justice Thomas says something prescient. And he said,
he says it's up to the states, yes.
Right. They dismissed a claim under the FCRA, basically identical or similar to the one here for lack of standing because there wasn't a concrete and particularized injury. And Justice Thomas said, this may be a Pyrrhic victory because guess what? State courts aren't bound by Article 3. And they can hear cases and controversies where there isn't this sort of injury that's concrete and particularized. And essentially what you're going to get is state courts deciding these cases. And that point was quite prescient because this is precisely what is before the court, is an allegation of noncompliance with the statute. There does not need to be the particularized injury that you would find if you walked down the street and walked into a federal court and asserted the same claim.
So she's argued, and she will get up, I predict, and argue that your problem, though, is that the injury your client alleges has to fall within an area of concern of the statute and that you fail that test.
So, Your Honor, two things. One is, under the court's jurisprudence, you just look at the statute. What that line of cases deals with, area of concern of the statute, is who has a right to bring suit under a statute. So, for example, in the SJC's case addressing the Harvard law students case, where you had a Harvard affinity group bring suit under the anti-discrimination statute, Chapter 151B, for alleged unlawful racial and employment policies, discriminatory policies, the SJC said, sorry, but none of you are actually employees. The statute wasn't designed to give you a right to sue. That's not what's at issue here. The who that gets to sue is the consumer who receives the unlawful disclosure. Who else could possibly bring this suit other than Ms. Kenn? She's the one that received the disclosure form.
I took her argument to mean that the Attorney General might do something here.
The Attorney General has no authority. There's the only agency that enforces the FTC, or the statute would be the FTC. But there is a private right of action for private employees to bring suit to enforce this statute. And again, 1681N plainly provides a right for an employee who receives an illegal disclosure form to bring suit. So what I'll note is that at the trial court level, the trial court committed two errors. One was it should have just looked at the statute and found that Ms. Kenn hadn't received a proper disclosure. If you look at 1681B in the FCRA, it has the disclosure and requirements. It has to be on a standalone form. Multiple courts have held that when there's extraneous information in it, it's a violation of the statute. And in this case, it did have extraneous information, including a release of claims. Then you just turn to the private right of action provision in 1681N, and it says you can sue for any noncompliance with the statute.
Is there any case? I mean, it seems to me between your colloquy with Justice Henry, the line between injury, and concrete particularized injury versus any injury at all. I mean, is there any state case where appellate court has held that somebody in your client's situation, somebody who has no particularized concrete injury, can sue under the language of the statute? Because it seems to me in all of them there is some sort of injury. Like the 93A, you say that it requires injury.
Right. Well, that's different.
Right. So is there anything where there's no injury, where the's no injury?
Sure. I think there's a host of cases cited where,
well, I mean, zoning, put that, let's put zoning to one side. Those cases, that's a different thing.
Your Honor, there just isn't case
and that's
law
worse for you
decided
anyway.
under the FCRA in Massachusetts.
And the 10 taxpayer suits.
Sure, the 10 taxpayer suits, that's a perfect example. Those are situations where 10 taxpayers can just sue. They don't have to have suffered any particularized injury whatsoever. They can sue under a number of statutes that this court has enforced.
But they have a generalized injury, right? Because they're footing the bill for what the town wants to pay for.
Sure. Well, and that's because the statute provides that they can, and that's why we look at the statute. The statute, you pointed to Chapter 93A. Why do we have to establish an injury in a Chapter 93A claim? Because the statute said so.
Right.
Because under Section 9 of Chapter 93A, it says you must have suffered an injury, you must have been injured by an unfair and deceptive practice. If you look at the FCRA, it says nothing about having to have suffered an injury in order to bring suit. It just says willfully fails to comply with any requirement imposed under this subchapter. The statute means what it says. There's no need to look beyond the text of the statute to say, well, did she suffer some other hypothetical injury outside of the noncompliance with the statute here? And the SJC has said in the LYRIQ decision that Congress can pass statutes the violation of which gives standing, even though there's no actual injury. And that's precisely what we have here, is we have a statute that provides that when you violate it, you have to pay minimum statutory damages, and that was Congress's judgment. I will note that the state legislature in Massachusetts has passed numerous statutes, including under landlord-tenant law, consumer protection, employment protection, that provide for these sorts of minimum statutory damages when...
Right, but then in the landlord-tenant, there's, you cite the subject matter of our on-bank case, it has to do with not providing water. There's an injury to the tenant who doesn't get, maybe it can't be quantified. I think my favorite line from the defendant's brief is nominal damages are provided where an injury is hard to quantify, not where there is no injury. So how do you respond to that?
Well, Your Honor, because it's a statute, and if you don't comply with the statute, you have to pay minimum statutory damages. There isn't a need for any separate injury. The SJC says that in Massachusetts, it can issue advisory opinions that have nothing to do.
Could I bring this case? I didn't get applied to a job for EASCARE.
Your Honor, are you
Employee,
any
no.
person, that would be an employer, who willfully fails to comply with any requirement imposed under this subchapter, which includes 1681B, which is the disclosure requirement, with respect to any consumer, that's the employee, is liable to that consumer, the employee, in an amount equal to the sum of actual damages or damages of not less than $100 and not more than $1,000. So unless the Commonwealth has provided you with a non-compliant disclosure form, no, you couldn't sue.
So you put this as a class action, right? So presumably it's going to include anybody who ever applied to a job.
That received this particular form that was unlawful. So it isn't that anyone can sue under the FCRA. Instead, it is folks who receive non-compliant forms. And the statute does not require a separate injury. This court's case law, the SJC's case law, has never required a separate injury with respect to a statutory violation unless the statute requires it, like under Chapter 93A.
Okay, so twice you've said there were two errors. The first one was look at the statute. In both other occasions, we never reached your second error.
The second error, Your Honor, and I'll do this very briefly, is, so as you may tell from the procedural history, this was filed in Superior Court. The defendants removed it to federal court, and then they immediately moved to dismiss it on the grounds that there was no Article III standing. And then so it came right back to this court, or excuse me, to state court, and the Superior Court judge, in dismissing the claim, said that the federal district court's analysis was applicable and persuasive. It was neither of those things as a matter of law, because the SJC has repeatedly said Article III does not apply in state courts. Yet, the trial court judge relied on the Article III analysis. As recently as the P.F. Chang's case in 2019, the SJC, in rejecting a district court of Massachusetts standing analysis, said Article III doesn't apply here. And it certainly doesn't apply here. The statute provides that you can sue for noncompliance, and Ms. Kenn has alleged facts demonstrating that she received a noncompliant form and has a right to sue under the FCRA. Unless the court has further questions, I'm out of time. And
all right, thank you.
Thank you, Your Honors.
Good morning, Your Honors. May it please the Court. My name is Sarah Spatafor, and I represent the appellee in this matter, EASCARE, LLC. Picking up, Your Honors, where my brother counsel left off, I think what's important to note here is the lower court judge did not apply an Article III analysis. Rather, what she found persuasive was the federal court's analysis of the intent of the FCRA. And that is purely within Massachusetts jurisprudence to look at when we're assessing whether or not there is a statutory standing argument. And when we look at who better to assess the intent of Congress than federal courts. And the federal courts have done this numerous times within the scope of the FCRA. And if we look to the Groshek decision, which is cited by the lower court, it's noted there that the intent of Congress was to create a mechanism by which there was no injury to consumers because they unknowingly or inappropriately, their information was given to an employer in a manner, or somebody else, it's not just in the employment context, but given in a manner that would violate their rights.
So our jurisprudence says we look at the plain language of the statute, and if it's clear, we just stop there. We don't go to intent. So why is this different? This says do X, they didn't do X. Why is it different?
I think the plain language that's relevant, Your Honor, to this analysis is whether or not there's a private right of action guaranteed in the statute, which it is not. The language that's cited by my brother counsel, and if it's looked at carefully by the court, establishes a standard for liability and then damages. It does not guarantee every consumer a private right to action that they can immediately walk in and claim noncompliance with the statute and be guaranteed nominal damages. Otherwise, we would see far more cases of this throughout the Commonwealth as well as the country, and we don't, because the simple receipt of a non-compliant form has not been found in this jurisdiction and several other circuits to be enough to establish a violation of the law sufficient to award damages. And to Justice Massing's point, consumer is not so narrowly defined, and I think the statute could be interpreted that any consumer would be aggrieved by one individual, one employer's decision to use a non-compliant form. If there is no injury requirement, then we're put in a place where we've opened the floodgates to potentially that attenuated level of litigation, where in this case, all that was required was for Ms. Kenn to allege that she had been misled or her right to privacy had been invaded. They had multiple opportunities to revise their complaint to make such an allegation at almost the direction of the court and chose not to.
Yeah, he seems to have a particular agenda here, and I don't fully follow it, but he does, I thought his brief was fairly clear and worked very hard to clarify an argument that she's saying you did not have a valid authorization to get my report, and so I have an injury, and I don't see you squarely address that.
Because I don't believe, Your Honor, that that's alleged in the complaint, which is the standard that we're looking at here for a motion to dismiss. While he may be clarifying that argument through his brief, the complaint itself, which is in paragraphs 25 through 28 on a record appendix page 16, simply alleges that applicants like Ms. Kenn could have suffered an injury, not that Ms. Kenn herself suffered an injury, which is what would be required under the Iannacino standard in Massachusetts to be able to make pleadings that are aligned with, not just plausibly connected to, an injury in this case. And again, the bar is not high. It's simply that she was misled in the provision of her disclosure form to the employer.
So you don't think she's included in being an applicant like her? I mean, it's saying applicants like her, and she's like her.
Possibly. I don't think that that's enough to meet the standard articulated by Massachusetts courts, by the Supreme Judicial Court, in order to say that there's allegations that would, again, the standard lead to or plausibly suggest that there's been an injury here. If that was the case, it seems unclear why it wouldn't have been alleged that way. That applicants, Ms. Kenn and other similarly situated applicants, have suffered an injury, or other applicants would plausibly suffer an injury.
Well, but come at it a different way. Did your client have a valid form that lawfully entitled it to get a consumer report?
Your Honor, contrary to what my brother counsel noted, my client has never admitted to any violation of the FCRA. I would argue that if this case does move forward, we have strong arguments to say we did not violate the FCRA. There's a requirement for willful violation, which is a high standard, which my client did not violate. So, no, Your Honor, I don't believe it's.
You never filed an answer, right? You
Correct.
filed a motion. So, I mean, we were accepting the allegation in the pleading.
Correct. And that's why we have not spent time arguing that we did or did not violate the FCRA, because it's just not where we are with regard to the litigation.
But you do say the receipt of a non-compliant disclosure form could infringe on protected areas of FCRA if the form created confusion, for example. And don't those allegations allege a plausible claim of confusion, misinformed about their rights? Or is it because it doesn't say misinformed about her rights?
That, Your Honor, that it's possible that people could be confused, but all people aren't the plaintiff here. There's one plaintiff who's seeking to represent a class. And if she wasn't confused about her rights, then I don't see how she was aggrieved by the statute, nor do I see how she can appropriately represent a class.
So you argue even if she can't proceed here, that the statute will still be enforced. How will that happen?
Sure, Your Honor. So presumably, any of the other applicants who received this form, if they did suffer an injury, if there were other applicants that received this form and suffered an injury, they would be permitted to bring a claim under the statute. Additionally, as noted by my brother counsel, the FTC is able to bring enforcement actions and have brought enforcement actions against companies that are inappropriately using disclosure forms that don't comply with the FTC. Primarily, the statute is designed to provide the government a way to provide a check and balance to agencies, again, not just employers, but employers in this situation, that utilize a form inappropriately in a manner which could infringe on consumer protections. So I don't see here that if Ms. Kenn, through this litigation, is unable to bring a claim against her employer, it prevents any other applicant who receives a deficient form that causes some sort of injury contemplated, again, a low bar under the statute, to bring a claim that there's been a violation of the FCRA. And similarly, it does not preclude the federal government from enforcing its own laws.
So can you clarify on the record whether the document we have is a double-sided document, or were they two separate pieces of paper?
Sure, Your Honor. My understanding is it was two separate pieces of paper, not a front and back document. It's produced as front and back in the appendix, I believe, to save on space, but I believe it was produced as two separate pieces of paper.
We can't tell.
Oh, okay, my apologies.
You're just one page after the
One
other?
page after the other, yes, Your Honor. I believe it was produced on two separate pieces of paper.
So you might have already said this, but so what would be a hypothetical situation of a consumer who could bring a lawsuit?
Sure.
Based on, right. I mean, is there ever going to be an injury based on this disclosure form?
Absolutely. So, and a consumer who says they were confused, that they would not have signed the form but for the inclusion of the extraneous information, that they were confused about what information the employer would be requesting about them, who suffered an injury because the employer got the wrong form about them, the wrong information, which deprived them of an employment right or an adverse employment action. But I think it's simple as they were confused or misled by the use of a non-compliant form, and or to Justice Henry's point, they believe the form that they provided was non-compliant and therefore resulted in an invasion of their privacy. But again, that just was not pled in this case.
So is the idea that the applicant can just refuse to sign the form, and is there a penalty? I mean, can the employer then just say, well, we're not hiring you?
An applicant can absolutely choose to decide if they don't want to sign a form, and if they raise a valid objection, the employer, I would think, in most cases, would look at that valid objection to say, well, why are they raising this concerns? Perhaps call employment counsel to see if they are using the wrong type of form. There is no background checks were required as a condition of employment after the conditional offer of employment's made, as is typical in the industry of an EMT. It's an emergent medical
They're in people's
service.
houses, right?
Correct.
While they're vulnerable.
Correct, and providing medical care, and there's a level of public trust. So I don't want to undercut the fact that background checks were a condition of a full offer of employment. However, I think had the plaintiff, the appellant, raised a concern to say, I believe this is overbroad, I'm concerned about what information you're going to have access to, that would have allowed for a conversation. And certainly whether or not the FCRA would have entered into that conversation, but it would have allowed for some clarification. I think simply what happened here, Your Honor, is the appellant brought unrelated claims relating to her employment, and as part of a personnel record request, noticed that the form she signed may have non-complied with the FCRA. There was no injury until she received her personnel file that was cognizable to her, and in the pleadings themselves, there is no injury stated that would rise to the level of allowing for this claim to proceed under counts 3 and 4.
Yeah, I would think a more typical injury would be not getting the job because of it disclosed, or finding that it was disseminated.
Correct.
what's-
Or the wrong information was pulled about the wrong person, or it resulted in a negative impact on a credit report. Those things can all absolutely, and have been, I think, claims brought by plaintiffs as injuries.
And they're specifically addressed in the statute, too, is what's supposed to happen, right? There's a whole series of...
Correct. And as noted in the Groshek decision cited by the lower court, the idea of the form compliance was merely the tool Congress used to try to assure that these injuries did not occur. It was not an entitlement to relief. And I think that is what my client has worked so hard to oppose in this litigation, is that if this court were to agree with the appellant, it would be creating such a low standard under this statute that it would allow potentially not even people who received the form, but any consumer to bring a claim against any person who potentially used a non-compliant form.
Well, although, I mean, but it's just to counter, the argument being made is that that's what the statute says. Why don't we, and are you saying that Mr. Moslinger is wrong, that we don't apply what the standing that the statute gives?
I would say that the statute does not confer standing in the way Attorney Moslinger has outlined to this court. I think the statute in the section that he cited in particular notes the standard for liability once standings as established by a plaintiff, but it does not create an automatic right. The way the statute is worded, it says a person will be liable to a consumer for willful violation, and these shall be the remedies. It does not say any consumer may bring a private right of action against any person who utilizes such a form. And I think that there, Your Honor, it also does not remove an injury requirement. The statute is written within the federal jurisprudence, which requires an injury requirement, right, under Article 3. And while Article 3 doesn't apply here, it's certainly instructive that that would have been the rationale applied by Congress when creating such a statute, and that an injury is not, again, not a high bar under Massachusetts case law to assert, and certainly an injury under this statute. If Your Honors have no further questions,
Okay.
I'll rest on my brief. Thank you.
Very interesting case. Well briefed, well argued. Thank you very much. That doesn't make it easy for us, but so we're going to take our usual break here for we'll be back in 15 minutes to hear the fifth case, which will be the Littleton case.
Court is in session. Please be seated.
We are back in session to hear case 22P656, McDonald versus Kazokas. Hope I said that right, and I hope that counsel will correct me.
Good morning, Your Honor. Ginny Sinkle-Kramer. I am counsel for the plaintiff appellant, Ken and Jody McDonald. This case presents a very unusual circumstance where the record is replete, not only with evidence of the extreme bias of a local decision maker, but also a record that is crystal clear that the decision maker completely ignored the standard by which it was to determine whether or not to grant the requested relief. If the board's actions in this case are held to be acceptable, there are essentially no rules for local adjudicatory bodies in determining the substantial rights of the parties before them. It's difficult to imagine a case in which the level of bias and lack of fair play could be more starkly demonstrated. A perusal of the transcripts of the local proceedings.
I just want to, there's many puzzling things about this case, but one thing that puzzles me about the bias is, I mean, there's definitely lots of expressions of sympathy for the applicant, but there's no inkling and no claim that there's a conflict of interest or any bribery or any kind of misconduct. It's the bias seems to be based on the way the case is going, not on anything extraneous.
Well, I mean, the misconduct may be doing a lot of work, but the misleading of the plaintiff appellant in the emails where he twice asked the chair of the board if this case was going to be discussed at that meeting, and
yeah, but she said be here, and then I presume she's busy, as we're all busy, and he could have sent somebody. I mean,
she didn't say be here. She didn't respond.
Right. The first email was you should probably be there, and then he's like, but what's going to be covered? And she doesn't get back to him, and then you just act in an abundance of caution.
Okay. Well, regardless of that email, when the individual seeking the variance came to the board's hearing, they came with counsel who made several misstatements of fact to the board. There was
what were the misstatements of fact?
The misstatements of fact was that the matters had been, the abutters had been appealing from the very beginning. In fact, the record is clear that she sat on her permit for 2 years and 9 months. The statements made by her counsel at that meeting, the counsel who was on a first-name basis with the members of the board, were completely misleading in characterizing the abutters as aggressors who are targeting her. It was
excuse me for interrupting you. Are we to infer something from the fact that there was a first-name familiarity?
I just think that the totality, there's no one thing in this that I would say, well, if you have that, then you have to throw out the decision. What I'm saying here is that the totality of what occurred here was so blatant and so brazen and so unfair that any pretense of any professionalism or objectivity of what is a quasi-judicial body is just out the window. I mean,
So I actually want to ask you a preliminary question and then come back to this point, but you both have identified a flaw in our rules as far as I'm concerned, which is we should be asking the appellee, do you agree with the statement, the standard of review set forth by the appellant? Because what I got from you guys was both two very dense pages of text. So when you read his recitation of the standard of review, do you agree with it? Are you two in agreement?
I'm not sure, Your Honor.
Yes, it felt like a puzzle for us to figure out.
So I apologize for that, Your Honor.
Well, it's not your fault.
The cases are, there's many cases that
It's
discuss
okay. You've
this.
told me
Okay.
you're not clear,
So
I'm
there are
going to ask
essentially
him.
two tests under 249-4. And we're asserting challenges that invoke both of those tests. Here, the plaintiff appellant is asserting, and I think the record is clear, that their use of improper criteria in the board's analysis. They not only fail to engage with the standard that they're supposed to be deciding this under, they don't even mention it, not once in either hearing.
I mean, I completely understand why your client might feel this is unfair, but I think some people might argue the government has failed all of these people by having this process with the Board of Health, the Conservation Commission, and the Department of DEP, and 2 different appellate processes from DEP, and that we could have sympathy for everybody in that circumstance.
Right, Your Honor, which is, the basis upon which the ad hominem attacks against my client were made by counsel.
So you're saying, the implication was that is it correct, your client did not appeal the 2014 permit, right?
I don't believe so. Right, correct.
And then she waits 2 years and 9 months to go to is it the DEP process?
It's actually the Conservation Commission process.
Okay.
It's very convoluted.
And then at that point, your client, at some point, she gets what she needs and your client appeals.
See, what happened here, Your Honor, is a septic permit is only valid for a 3-year period.
No, that part I got, and then a 1-year extension.
So when you get your septic permit, then you proceed to CONCOM to make sure that you have the correct delineation of the wetlands. I don't know why she waited 2 years and 9 months, and I'm not faulting her for it, but what I'm saying was that's what she did, and then she turned around and blamed my client for appealing the extension when he did. She didn't build it within the generous 4-year window that she had available to her. And then she blamed my client, and the board piled on. It's not fair. He handcuffed you. This is a local person, 3rd or 4th generation. We have to help her. All of that. I mean.
So, but you argue that the record clearly establishes that the plan Kazokas submitted with her 2018 application was the out-of-date 2014 plan and was somehow different from whatever the plan was in 2018. And there's a long footnote, but can you walk me through why they're different?
Sure, Your Honor. In fact, and this was a level of confusion in front of the board that even it took me until I was preparing for this argument to really understand. What the board was saying is we don't care where the wetlands boundary is because that's an issue for CONCOM.
Right.
But what my client was saying was the change in the delineation of the wetlands boundary, and you have to set the septic system off of the wetlands boundary, changed because the wetlands boundary changed. And so even their own health agent stated in the memo to them that the most significant change was to the retaining wall and to the septic. That's in a memo that he wrote to them.
And that's at page what?
I can find that for you. I definitely have it in my notes here.
We're able to search by text. Can you give me a name or something?
So it's Gareffi.
Yeah. Okay.
I will find that citation for you.
All right.
There are several places in the record where it was clear, and even counsel asserted that it's substantially the same. The location of the septic is substantially the same as a 2014 plan.
Well, but at this point, the septic part of it was in the ground already, so they weren't.
But in order to determine whether or not they would be granting the variance, they needed to engage with the standard for granting the variance and look at a plan that showed where this was going to be. I mean, they didn't even pretend to be interested. Their entire basis for approving the variance was that it had been granted before. I mean, if that's the standard, you should have a box to tick that says, was this variance granted before? And if you tick yes, you get your extension.
Well, I think there might be an implication that maybe the rest of the process is so slow that the 3 years/4 years is just not long enough, and we're doing a disservice to people, not just her, but just generally. If our process takes that long, then we're kind of putting people in this ridiculous situation.
Your Honor, I think that you can't excuse the board's failure to engage with the regulation that says what they need to decide in order to grant this relief. A
Okay,
variance,
all right, so I understand that, but you cite pages 186 and 187, and you say basically that somewhere on these 2 pages, there's an alternative site for the septic system. And unless you tell me exactly where that is, I have no idea how we're supposed to figure that out.
and I can do that, Your Honor, and unfortunately, you know, I was stuck with the administrative record as filed, and that was the plan that was included in it.
But can you give me any kind of hints?
I can give you, yes, I can do that.
I'm looking at it as an orientation where I can read it, you know, so it's like, can you give me a quadrant?
Okay, so if you're looking at page 186 and 186, the middle, so this lot is so long and narrow that it's
Yes.
actually broken up into pieces.
Right, and the middle thing says existing paved driveway sort of through the middle of it.
Right, so it's below that existing paved driveway are 4 kind of diamond squares, 2 and then 2 more to the southwest of those. So under the existing paving drive, and I don't, this is just, you know, underneath there are squares which denote the test pits for the other location for the septic. And then in addition to that, there are several places in the record that state, for example, at page...
Wait, don't go yet. Because I had a question about whether there were 2 or 3 alternative placements of it, and where would those be?
So that was another point of contention, of confusion at the hearing, because the board and, you know, with the aid and assistance of counsel, I'm not sure, conflated this second approved location with a location up by the road where no test pits were dug, and with a statement by the Board of Health agent that he wouldn't support a septic location that far away. That was not the second approved location for the septic. And, Your Honor, you know, the Board of Health understands what these plans mean, and they had a lot of, you know, separate pieces of evidence in front of them that there had been a change in the location. And even though the standard that they were required to use was, would it be manifestly unjust to enforce this? This is 2 feet from his property line. They're building a 40-foot long retaining wall, 2 feet from his property line. So up high, holding back the fill for 40 long feet. When the regulation says 10 feet. So the question before the board is it manifestly unjust to enforce this 10-foot setback? And when you have 6 acres and an alternative location, how can you say that it's manifestly unjust?
But what's the proof that there was an alternative location? Or are you saying she had to prove there was no alternative location and she just didn't?
The board had to at least engage with whether there was manifest injustice, and that would necessitate them saying,
I think their focus might have been not your focus, which was they're saying this whole governmental process. I get that your client is, you know, getting ground by these wheels of government too, but I think their focus on this was that she was getting ground up in the wheels of government. Whether they were right or wrong and she waited 2.9 years, I get that. But like,
I think that's a very, very generous interpretation of what they were saying. What they were saying was your mean neighbors, you poor honey.
No, I think,
you know, I mean, he calls her honey in the,
I still believe me, I saw, yes.
It's outrageous.
No,
It's
no.
outrageous.
Yeah, we saw that.
Showing by a local administrative body. It's just outrageous. And the fact that she was represented by counsel who egged this process on is really troubling. And when they came back for the public hearing, the board felt that her counsel were their counsel.
I take it you're saying the standard for manifest injustice was that they had to consider whether there was some alternative that did not require a variance, and they didn't do that.
Right, whether it can't be manifestly unjust to enforce a 10-foot setback if there's another location that she didn't have to meet it. So,
And is that and I think there's an argument from the other side that you're conflating the Title V 310 CMR standard with the Regulation 27 standard.
The regulation's very clear about what its standard is. It is also manifest injustice, so it's there in the record.
So, but you're not arguing that the
Title V applies? Absolutely not. No, absolutely not. So in closing, I just want to say that under these highly unusual and very limited circumstances where the adjudicatory body showed a stunning favoritism and total hostility to the other side, failed to even engage with the relevant standard for granting the relief they allowed, and wholly ignored evidence of a second approved location that would have undercut their finding, this court should correct those substantial errors of law that affected the McDonald's material rights and annul the Board of Health's decision.
One quick question, and maybe off, is...
Don't sit down yet.
The septic, it's there. It's dug, it's there, it's...
Yeah, she put it in
okay.
while it was.
That's
yeah.
all there. So it...
I don't know if it's all there,
consequence
but it's
practically is
largely
that it'd
there.
be dig it up, pull it out, put it somewhere else.
Right.
Okay.
So you say, yeah, don't sit down yet. You say there is a documented successful alternative septic location on her plan, but what's the record citation for that?
Okay, so, Your Honor, if I may, okay, there are several places where, okay, so if you look at RA 45, you have an email from Gareffi, the Board of Health agent, and it's paragraph 3. There's a revision that shows additional topography, and it does differ slightly, the well and the retaining wall being the most significant. So that's one indication. And then the actual memo from Mr. Gareffi, I'm sorry, I thought I had this so belt and suspenders, but if I may look for that while my brother is arguing, I will get that citation to you.
Okay, and your client's neighbor argues that you erroneously rely on Lucier versus Zoning Board of Appeals of Peabody for the proposition that variances should be sparingly granted, and they argue that the case caption itself shows that the Lucier court was interpreting zoning variances under Chapter 40A, Section 10, the Zoning Act, not Title V or not the locally adopted regulation. What do you...
That's correct, Your Honor. To 48 Section 10, there is something called zoning variances, but a variance, just as a general matter, is varying the laws in a very specific instance. So you pass the laws because you say these should apply to everybody, and they should apply to everybody equally. So when you give a variance, you need to be very careful because otherwise the exception will swallow the rule. So you can't just willy-nilly grant them, and even though that particular case was talking about zoning variances, the concept that variances give somebody a different set of rules to play by, those should be sparingly granted across the board, no matter the context in which they're given. And I think that, perhaps there's another case I should have cited there too, but.
And you offered, I think your client offered their own expert, this Mickey Marcus, about wetlands delineations and that the 2014 plan was incorrect. Does your appellate argument rely on that at all?
It was just one more indication in the board's record that they acknowledged they had that they completely failed to look at or engage with in any way, shape, or form. The level of negligence of just barreling to the conclusion to give this third or fourth generation resident what she wanted because it was an emergency and they couldn't send her away, was ignoring relevant evidence in the record and refusing to engage in it, which is another thing that makes this case very unusual as a local practitioner.
One more. Justice Henry let you off easy on the standard of review. You cite the standard for 249-4, which is what the Superior Court applied to the board's decision. What do we apply? Are we reviewing the board's decision or reviewing the Superior Court's decision?
Well, Your Honor,
Is it
you're
de novo,
right.
or is there any kind of deference that we give to the Superior Court?
I don't think that that deference to the Superior Court is required where you're looking at the exact same thing. There was no live testimony. There was no, determination of credibility of witnesses. So it's a paper record before the Superior Court, and it's a paper record before this panel. And there was just so much in the record that the Superior Court failed to consider. I'm going to find that site for you.
Okay. And so just, and if you want to give us that other citation, let's do it in this form of a letter.
Okay.
So because we don't have rebuttal.
Certainly. Okay.
And just one more word to the wise. So I was flipping through your brief to look for the decision of the board, and it's not there in your brief. It should be in an addendum. And I noticed that your certificate of compliance at the end is actually under the old rules.
Okay.
So you might want to update it for future briefs.
Okay. Thank you, Your Honor. I will.
We have a lot of rules. It's very hard to find them all.
But I always look for the decision of the court in the brief.
No, he
Yeah.
makes a fair point. I'm just,
Yeah.
I think that when you could hit someone with the rules and actually kill them, that maybe we should think about whether we have too many rules, but.
Okay. Attorney Costa.
Good morning, members of the panel. My name is Adam Costa. I represent the private defendant, KRISTEN Kazokas, who's here in the courtroom with me today.
How do you say the name?
Kazokas.
Thank you.
Your Honors, I'm going to try and go off script a bit in terms of my preparation for today and be responsive, maybe in reverse order, to some of the recent comments that were made by my sister counsel and in response to some of the questions that were asked by the justices. So, Justice Henry, you asked a question about the Lucier case and the standard for the issuance of a variance. So the Lucier case is a zoning case that arose under Chapter 40A, Section 10. I don't dispute the language of that case, which indicates that zoning variances are to be, quote unquote, sparingly granted. But there are plenty of cases that address the variance standard in the context of Board of Health actions. And the standard's very different, which is important. And in fact, I cite them specifically in my brief. So the Mullane versus Zada case, which was a trial court case, a land court case from 2008, said that the standards for varying septic system requirements, whether under Title V or a local rule or regulation, as is the case here, are discretionary with the Board of Health, which is afforded broad discretion in determining when to grant a variance. I also cite to an appeals court case, a case of this court, Tortorella versus Board of Health of Bourne. Again, a Board of Health case indicating that the variance provision gives broad discretion to boards of health in determining whether or not to grant variances. So the standard is very different between Chapter 40A and whether it be Title V or a local rule or regulation adopted by a Board of Health.
Right.
Now,
Okay.
that sort of
and
is,
because of your briefs, I'm going to suggest to our rule committee that the appellees start with "we agree" or "we don't agree," rather than leave us to try to figure that out. But I take it you don't agree on what the standard is.
So I don't agree with respect to the difference between sparingly granted and broad deference, because the case law says what I just said it does. However, I do agree under 249.4 with respect to sort of the two-part standard that was applied by the Superior Court, this concept of arbitrary and capricious if the plaintiff is challenging a decision based upon an abuse of discretion, and substantial evidence in the event that the allegation is that the decision of the board was contrary to the evidence. That's the standard that the Superior Court rightly applied.
And are we applying that standard too?
Well, I applied it too in terms of evaluating generally the sufficiency of the decision of the Superior Court. But the one way that I would differ with my sister in response to a question that you asked, Judge, which was, well, what about here? This is the appeals court. Does the same standard apply? Well, I would say yes to the extent that errors of law are being waged, because you review errors of law de novo. You always review errors of law de novo. But if the allegations, and many of the allegations in this plaintiff's complaint are that there were factual errors made by the judge of the Superior Court, by Judge Doolin, well, those are reviewed under a clearly erroneous standard, a very different standard than de novo.
So I took her argument at the highest level is to say that the board was considering whether to issue a permit, and it really shouldn't have been looking at that we did this before, but it needed to engage in the process again. And you, I take it, disagree with that.
Well, I do, and I also dispute that they didn't engage in the process again. Did they read aloud in their meetings every document that was part of the 2014 record? No. But I think that my sister has effectively conceded by virtue of the record that was not only filed in the Superior Court, but now included as a record appendix in this court. Look at that record. It dates all the way back to 2014. Those were the materials that were part of the file that was before the Board of Health. And there were statements in that record from 2014. We talk about what did the board rely upon? There's no question. The decision in this case, it's on page page 96 of the administrative record, the 2018 septic permit. It's a one-page permit. These permits are always one-page permits. It's the state form that issues under Title V. Even if the Board of Health is issuing a permit under a local rule or regulation, it's a form that they use, a one-page form. They completed the form, they issued the septic permit, they issued the variance. So the question becomes, okay, but what about the record? You review the record as a whole, as did the Superior Court under Standing Order 196. These sorts of cases are not trial track cases. They're decided on an exchange of motions for judgment on the pleading. We're limited to the administrative record. So what did that administrative record consist of? Well, it consisted of a few hundred pages of documentation dating back to 2014. And in 2014, plans were submitted by Ms. Kazokas and by her then engineer. Testimony was provided by her engineer in proceedings before the Board of Health. And most importantly, and this is key because this is what the board relied upon, the board has a health agent, not a local individual, not a volunteer, a resident of the town. The town utilizes the Neshoba Associated Boards of Health. The Neshoba Associated Boards of Health represent the number of communities in that area of the Commonwealth. They have professional health agents that work for those communities. Usually they spend 1 or 2 days in each community. And then they go out and they do things like inspections. They're familiar with Title V. They're familiar with the local rules and regulations. So let's look at what was said by the health agent back in 2014. The health agent said, number one, I don't have an issue with the request as the use of the retaining wall, speaking about this retaining wall to hold fill, will allow the surface runoff from the site grading to be directed directly onto the applicant's property. So that was evidence that was given back in 2014. Additional evidence, and this addresses another point that was raised by my sister about alternative locations. And I want to pause here and say, there was no concession by my client, and there is none now, that there are alternative locations for a septic system. This concept of alternative locations.
Was it her burden to prove there wasn't an alternative location?
No, and it wasn't her burden of proof. Let's look at the difference between the variance standard in Title V and the variance standard in the local regulation. So the Title V standard includes this phrase, which is omitted from the local regulation, that failure to grant the variance must, quote, deprive the applicant of substantially all beneficial use of the subject property. The case law under Title V says that's an alternatives analysis. That's how we casually refer to it. There needs to be an alternatives analysis. You have to look elsewhere in the site and say, could this be done somewhere else, or will we be deprived of all beneficial use of the property? That standard doesn't apply under the local regulation. The local regulation standard is two-part: manifest injustice, and the same degree of public health and environmental protection can be achieved without strict application of the particular provision. Now, that second part I just addressed when I quoted Mr. Gareffi, the health agent, who said this is going to be a good thing. It's going to keep the runoff on Ms. Kazokas' property and, in fact, not on the plaintiff's property. But let's talk about what was said.
Yeah, but a retaining wall 10 feet in would also keep the runoff on her property, too.
That's correct, but the retaining wall can't be 10 feet in because of where the system has to be located, hence the request for the variance. So there's this local standard that says you can't have fill within 10 feet of a property boundary. Because of where the system needs to be placed in the property to meet wetland setbacks and to not affect the adjacent pond, the system itself is going to be located almost 20 feet away from the plaintiff's property, but there's going to be fill that is in that area between, I think it's 17.6 feet, the edge of system to the property boundary, and the property boundary. There's going to be an area of fill and a retaining wall. That was what necessitated the variance.
So one of the things that does seem less than ideal is that the board approved the permit based on a 2014 plan, not the 2018 plan, and it didn't seem to even have a 2018 plan in front of it, right?
It did not.
So what is the implication of that?
I think there's no implication, and in fact, nor did the Superior Court judge, who spent a lot of time discussing it in his decision. And so he said a few things. He said, number one, at the hearing on September 25th, that was 2018, Mr. McDonald, the plaintiff, did not argue that Ms. Kazokas was intentionally misrepresenting her plan. So this is a new argument that's arisen in these proceedings. It wasn't raised below. Number two, there is evidence, aside from the McDonald's assertions, to support these claims in the administrative record. Only one set of plans is in the administrative records. Although the plaintiffs twice moved for and were granted leave to expand the record, they did not seek to include these supposed additional plans. And then the last one, which was in a footnote in the trial court decision, and an important footnote, is that much of the material in the McDonald's other cases, referring to the 3 other lawsuits pending against my client, was created or filed subsequent to the board's decision on September 25th of 2018. So what this court should understand is that these other lawsuits, which primarily challenge conservation issues, wetlands issues, proceedings before the OADR as an agency of DEP, proceedings before Superior Court under the local wetlands bylaw, these all began in late 2017, around the same time as the proceedings here, but they have continued on. In fact, those 3 cases, 2 of them will soon be before this court, and 1 of them is still in the trial court. And so as a consequence of those proceedings, there have been some adjustments made to the plan for conservation purposes. For example, the edge of pond was redelineated. We're not near the edge of pond. We're on the other side of the residence, 150 feet away from the edge of pond. So the septic system...
But the point is the 2018 plan is in the judicial record somewhere, even if they're not in this particular case's judicial record.
That is correct. That is correct. But the 2018 plan is not going to show that a septic system is being proposed in an entirely different location than where it was proposed before. And representations were made to the Board of Health that it was in the substantially same location. That was verified by the town's health agent.
I'm assuming
And
it's in the same location because it was already partly in the ground.
Well, that's correct. And this sort of goes to the sequence, right? So a Board of Health permit, septic permit, is good for 3 years. And we talked about this 2 years and 9 months, and the implication is that my client sat on her hands and didn't do anything. It takes some time. It takes money to invest in a septic system. It was engineered. Approximately 2 years and 9 months, work began on the system. A 1-year extension was then granted, so it's not as if there's only 3 months left over, because now that's a year and 3 months. But during that 1-year extension, in fact, even during the 3 months at the end of the 2 years and 9 months, there was litigation pending filed by these plaintiffs challenging the ability to proceed with the entire project, the renovations to the cottage, the relocation of the driveway off of the plaintiff's property. All of these proposed changes to the site were being challenged. So yes, my client began installing the system. The system is substantially installed in the location where it was approved, but it's not completed, and the other work on the site hasn't been done because under the Wetlands Protection Act, you're not authorized to proceed at risk.
So you seem to say that it doesn't, the 2018 plan versus the 2014 plan doesn't matter, right?
I say it doesn't matter because there's no substantial difference between the two as regards the septic system.
Did somebody make a finding of that?
Well, in fact, and it's in a footnote. It's footnote 8 in my brief. Maybe I shouldn't have relegated it to a footnote.
I was going to say we don't like that, but okay, sure.
So I apologize. But there's a reference to the fact that there was actually a presentation of excerpts, and they're in the record. I think I have a record cite for them. It is Record Appendix pages 54 through 56. Mr. Greffey, the health agent for the town, in fact, did supply the board upon request with excerpts from the plan that was then before the Conservation Commission. Not the entire plan, there's not a full-size plan, but excerpts from the plan showing the location where the septic system was proposed. These excerpts are significant, I say in my brief, for what they do not show. Contrary to the petitioner's assertions that Ms. Kazokas had significantly altered the location of the fill in the retaining wall, if you compare these excerpts with the original 2014 plan, which is in the record appendix, pages 186 and 187, it confirms that the placement of the septic system and the location, the length, and the size of the retaining wall didn't change between 2014 and 2018.
So when we look at 186 and 187, which is not sort of Greek to me, as it were, what are you wanting us to? I think I get what she wants us to look at. What do you want us to look at?
Well, I want this court to recognize that because there's no alternatives analysis required, it wasn't necessary for my client to look at other potential locations. But maybe more importantly than that, these other locations, even though my client didn't bring them forward, they were brought forward by Mr. MacDonald during the proceedings, and so they were addressed by Mr. Greffey. He addressed them in a couple of ways. One time I've already referred to, but let me talk about the second time, and this is also in the record appendix. It's on page 155. So the health agent explained the applicant tested 2 locations in the lot, and in both locations there was an adequate amount of soil. The design of a system in either location, quote, would likely need a retaining wall. So if we're comparing apples to apples, and they're saying there can't be a retaining wall next to our property.
So what are you reading? Because our record appendix 155 is a transcript, and you're holding something in your hand that is decidedly not a transcript.
That's an incorrect reference. It's page 23 of the record appendix. My apology.
That's okay.
There was a second statement on 155 where, so the first statement was from 2014.
Right, but let's say, though, hypothetically, and I understand you might disagree, but let's say she had a perfectly lovely place that didn't require a variance, but you're saying she can still get a variance?
I'm saying she can, based upon
Even
what's...
if there was a place that didn't require a variance?
That's correct, because there's no alternatives analysis required. She need not prove that placing the system in a location requiring the
But then
variance.
why? What's the standard other than a local board liking somebody versus somebody else? If if she can do it within her property, why should anybody get a variance?
Sure, so the standard is manifest injustice.
So why is
if
it
were
manifest
shown-
injustice to put it where it can go without a variance?
Well, I guess my point is I'm not sure where can it go without a variance, because the health agent said in 2014, if you put it over here, you're still going to require a retaining wall in that location. That's not going to be environmentally any better than what you proposed. And then he addressed this concept of another location, and I think this is where some confusion arises. So here's what he said concerning another location. He said, I wouldn't recommend placing a system, quote, up by Fort Pond Road, which is what had been suggested by the plaintiffs. The reasons being, his words, reasons being that placing a system not far from the proposed house would mean increased maintenance, a larger pump, more sewer lines to possibly leak, and so on and so forth. So the town's own health agent looked at the evidence and said, we don't want to put it in a different location. Again, I'm not conceding that there's...
I understood her to be saying that's not the location she's talking about. She's talking about a different location.
Right, and so with respect to the other location, that's where he made this statement that he didn't have any issue with the variance request, and he said, I don't have an issue with the request as the use of a retaining wall will allow the surface runoff from the site grading to be directed onto the applicant's property. That's this environmental standard. He has to look and say, is placing in this location going to be any worse, any better environmentally? He determined that this was a better location for the system. It was going to direct stormwater onto Ms. Kazokas' property.
So where in this record does the board engage in any kind of manifest injustice analysis?
It does not.
It does not, okay.
It does not.
Is there, okay, okay.
And well, let me address, well, I have, if I could answer the question, I have 1 second left. But with respect to this issue of what needs to be included within the board's decision. So the reality here, as I mentioned before, is that this is a one-page decision form that is completed. I represent municipalities. I know municipalities, volunteer local boards. They often don't engage in detailed analysis and issue 10-page decisions with findings of fact. There is no requirement that they do so, and I've cited the cases in my brief saying so in these circumstances. There are other statutory and regulatory schemes. Again, my sister referred to some zoning case law a bit earlier. If you refer to Chapter 40A, there's language in Chapter 40A that says detailed findings need to be made by the board. That language doesn't exist in Title V. It doesn't exist in the local regulations. So the standard for review is the administrative record as a whole. That's why it's a Standing Order 196 case before the Superior Court. That's why the whole record was available to that court. That's why the whole record is before you today.
All right, so you have a statement in your brief that the wetlands delineation challenged by the McDonald's has now been affirmed by this honorable court. I suspect you were cutting and pasting and you meant the Superior Court?
I did.
Okay.
Thank you. Yes, the appeals are currently pending in this court. They've been affirmed by the Superior Court and by the Office of Appeals and Dispute Resolution at DEP, and prior to that by DEP.
No. You going forever?
Yeah.
So I commend you both. You both did an excellent job for your clients who are here. So both of your lawyers did a great job. Lots for us to do, and the case is submitted.
Thank you very much, Your Honors.
And our last case for today is 22P1168, Department of Children and Families versus Mother. And I guess this probably brings you guys back to the bad old days where your DCF cases were always last. Well, here you are again. It's just random. It's just random draw. And I understand, and they understand the department will be taking 10 minutes and the child 5 when it's your turn. Okay. Attorney Blanchette, floor is yours, or the mic, or the podium.
Thank you. May it please the court, I'm Madeline Blanchette, and I represent the mother in this case. In DCF, instead of providing mother services tailored to teach her how to meet her son's special needs, instead cluttered her patchwork of service plans with nonsense tasks, thereby creating no reasonable pathway to reunification. The lower court here made voluminous findings that mother was not able to meet her child's special needs, but DCF had control over her child and did not invite her to participate with the child's providers, where she would have learned how to meet those special needs. So throughout the record, there's many quotes where the lower court faulted her for not knowing how to address her child's special needs. I can just turn you to some findings, 337, 59, 80, where the lower court said lack of supports is the major issue. In the summary, she said, this child has autism, has specialized needs. The caregiver will need to work with services. So the problem here is that DCF did not take the opportunity to engage mother with the services that the child was engaged in at the grandparents' house, and did not.
Let me just stop for a second on, like you just, 337. As I understand that, that looks like a service directed just for the mother without her needing to involve the child.
Are we talking about the UCP service, Your Honor?
You gave it as an example, finding 337. Mother has not yet engaged in any autism educational services or supports at the time of the assessment. I understood those to be for her on how to deal with a child with these issues.
Well, that opens a window to a complex controversy over autism services in general. So it is true that she was referred by her second social worker to UCP, which is the United Cerebral Palsy organization. And when she contacted them, UCP said, I'm sorry, we can't help you because you don't have custody of your child. When the social worker testified on cross-examination, that's the transcript site 525, he acknowledges that at the time he made that referral to mother, he didn't realize that she would hit that roadblock. So, for example, medical appointments. Because the child had significant special needs, going to the physician, the pediatrician, was not just a run-of-the-mill thing. It was a very important opportunity for mother to learn about the child's special needs, learn about the services that he required. And the social worker one said mother was not invited. Grandfather just did that. Quote, that was handled by the child's grandparents. I did not invite mother to any appointments. I did not call her and say, you know, he has a checkup on this day. Mother also confirmed in her testimony that since the child had been removed, she had never been invited to the doctor's, any doctor's appointment. Now, going to the school, the child had a lot of specialized services that went through the school. For example, 3 times a week. He had some specialized language and speech help. Mother was never invited to the school until in 2021, having DCF recognizing that it failed to bring her to the single IEP meeting that occurred in this case, which my brother said on page 30 of his brief that mother did go to an IEP meeting, and that is just not in the record. She did not go to the IEP meeting. She was not invited. And in fact, the lower court, that was a rare instance where she did make a finding about a lack of reasonable effort. She acknowledged that the mother was not invited and then unfortunately said, well, it's okay because if she had been invited, she wouldn't have participated or gotten anything out of it. So anyway, to make up for this egregious oversight of keeping her away from the IEPD meeting, which you can imagine is a wealth of information on the child, the special needs, the services, they did arrange for her, again, once the trial had started, to go to the school and meet the teachers and hear some information about where he was at. At that meeting, she discovered that he had been held back the previous year. So this is how totally out of touch she was because of being blocked out of the child's services, the child's providers.
So on your brief, when you list out in pages 40 and 41, you bullet out all these tasks, are you saying every one of these was impossible for her to meet? Because she didn't have him or for some other reason?
Your Honor, that is that's a second argument that I make. So yes, on these pages of 40 and 41, I'm saying these are the nonsense tasks. Mother did not have custody of her child, so she could not ensure that he attended school on a daily basis and on time. She could not address issues that would arise at school. She was not able to ensure that he was supervised by an appropriate sober caregiver. She, could not ensure that he attended all his medical and dental appointments. Again, this was a long, long list of things which, really documents not DCF's finest hour here. This was very, very shoddy service plans. I also, when I did a list of all the service plans, which I also included in my brief in a table, I discovered, that's on page 37 of my brief, I discovered that there were actually gaps where mother had no service plan at critical times. And then...
that was impressive detective work.
Thank you, Your Honor.
What do we gather from that? So, the service plan, it becomes out of date. Does mother look at it and go, oh, I don't have any more service plans, or does she just assume that I should just keep following the old one?
Your Honor, that's a really good question, because when I looked further at those service plans, that were put into evidence, I could tell just through the chronology of the case that they covered periods of time that the author of that service plan was not working with mother, and in fact, in a couple of instances, was not working for the department. So I don't know, in fact, whether those service plans existed at all, or they were, my guess is they were backdated. I don't know if they were prepared for trial. I can't speculate, but they don't make sense, and they refer to periods that aren't even inside of the case. So I think that the problem that I'm really trying to...
Was she having regular meetings? And I know you mentioned there are lots of different social workers as well, but were there regular meetings with social workers?
Yes, she did. That was something that she was really compliant with, regular meetings with the social workers. She also had regular visits with her son. I think the record is clear that those visits went very well. She was very affectionate. She was very loving. She brought toys for him. She brought snacks. She had little activities despite his special needs. But, it was really a lost opportunity, because here she was demonstrating that she had some really strong fundamentals as a loving mother, but nobody was coaching her on how to actually address his special needs, which is what she was ultimately faulted for. So yes, while she's there in the DCF visit, she's got flashcards and animal drawings and stuff like that, but she's just being passively observed by a DCF social worker, who then did make notes saying mother was very nice and appropriate in visits. But again, such a lost opportunity to try to teach her about autism. Moreover, the list of specialized autism services that the grandparents received, through UCP, ABA, came to the house twice a week, home services. The social worker testified that the social worker had collaborated with the grandparents to get DDS services. It's a no wonder that they were so skillful with the child. They were flush in services. So what I'm saying is, this was sort of a compounding injustice, where not only was she tasked with knowing the child's special needs, she was blocked from accessing information about that. Then this was poured onto the grandparents. So that was a pretty, it was pretty much impossible to compete with that.
So
and then,
I think the department is probably going to argue that even if everything you say is correct, there were all these situations that led to his removal where the mother just didn't understand his needs, that she wasn't even if she didn't understand his diagnosis, she wasn't providing the consistency, that she didn't understand the feral child diagnosis, that she didn't understand that he was probably suffering from PTSD. So even if the department, did all the things you are saying, there was just a lack of comprehension up until the removal. And what do you say to that?
Your Honor, what I say to that is that that the second time that the child was removed, mother engaged significantly in services. And I know my brother says on page 41, critically, mother never engaged in any autism services. That is just not true. If you look at the testimony on page 619, mom was engaged in a parenting class that specialized in autism. So as a part of her reunification process with the second removal, she did engage in those services, and then she maintained in those services. And then what ultimately led to, undeniably her dysregulation was a tragic death of her partner and her child's father. So, this was not what I would call an unforced error. I mean, she had a catastrophic thing happen in her life. So I would say that she is actually someone who did benefit from services. And then I'll even just say that, towards the end of trial, when DCF was, maybe trying to show a little more reasonable efforts, and they then also invited her to an autism program that was in her community. The social worker testified that the meeting it went great. Like, mother was very involved, she was engaged, she was interested, and on cross, when asked, why did this not happen until March of 2021, mid-trial, the social worker said it was so late because of the pandemic.
So you gave a record citation I didn't understand. So I don't know if it's the department's brief or the child's brief, but you say on page 41 they made a statement that's not true, that the mother was not learning about autism, and you said, I thought you said RA 690 something, but I don't.
No, I'm sorry, Your Honor. That was DCF's brief on page 41.
Yes.
Said critically, mother never engaged in
Right, but what's your record citation that that's not correct?
Oh, okay. The transcript 619.
619.
619. Yep, and then again, so that was, and that was in the past when she had reunified and was getting quite decent services from her original social worker. And then again, when this sort of like Hail Mary, and they brought her in March, the testimony is on page 811. It was a great meeting, actually, and that's where the adoption social worker described the hour-long meeting that they had with the autism team, and said it was almost like a training, and mother had a lot of questions and was very engaged.
Nice. To the extent that, and there was perhaps some progress, would you agree that once the child's father died, at that point it seemed to be, as you said, a pretty catastrophic event that from which there didn't appear to be any real recovery?
I think that she was certainly in the haze of grief, Your Honor. Yes, when she was having so much difficulty prior to the child being removed. One thing that I thought was interesting, also going back to social worker Hang's testimony on page 622, the social worker, who was really trying, was looking for additional supports for her post the partner dying, and really hadn't been able to come up with anything, and then that's when she pulled in mother's adult daughter. So, this case has those limitations that are in the community, and on top of that, COVID, and then on top of that, you know, it appears to me that DCF removed the child and then put them with the grandparents where they were satisfied with the child's care, but that is not the standard, and I respectfully ask you to reverse. Thank you.
Thank you. Attorney Marks, still at it, huh?
Good morning, Your Honors. David Marks, Assistant Attorney General for the Department of Children and Families. The entire case must be viewed in light of the child's severe and significant needs, diagnoses, and limitations. At the time of trial, the child was 9 years old. He had serious diagnoses related to autism, post-traumatic stress disorder, ADHD, and the associated behavioral and developmental needs were significant. The testimony showed that there was a grave risk that this child would not make progress into adulthood, would become almost entirely dependent on caregivers if his needs were not addressed early. And this was a significant filter through which the judge viewed all of the evidence. Mother was unfit and was likely to remain so into the foreseeable future to parent this child because, one, she showed an utter lack of understanding or appreciation for both the child's own needs, and the judge made findings to this effect. For example, she disagreed with the prescription given the child for ADHD, so she refused to give it to the child, and the school had to do it. And she had a lack of understanding of her own abilities, deficits, etc.
Can you address, Mr. Attorney Marks,
Yes.
The argument that DCF didn't make reasonable efforts in this case, that the mother wanted to be engaged but just wasn't given a fair opportunity to be?
There were numerous action plans in place. So this mother had a relationship with DCF. In other words, DCF was involved in this mother's parenting of this child from the day he was born. So this was the third care and protection. The second care and protection proceeding had been dismissed in 2017. And after that dismissal, there was still an action plan in place that helped both the father and the mother parent the child. And then the father died at the end of October of 2017. DCF helped put supports in place to support the mother, including her daughter, and a parenting, I want to say it was a parenting aide. And everything seemed to be okay for a year and a half, roughly. In March and April of 2019, the mother is taking drugs that are not prescribed, benzodiazepines, doing marijuana. She tested positive for marijuana throughout the entire course of the case. And she only got a medical marijuana card towards the very end of the trial. And so by March 2019, she had deteriorated. Her substance use and bad judgment got in the way, and a new care and protection proceeding began end of April 2019. The action plans that are in place throughout this entire time, from before this care and protection all the way through trial, The social workers testified. They went over with her all the tasks on the action plans. If there remained tasks on the action plans that were, quote unquote, impossible, get the child to school on time, that was a vestige of an action plan that was in place before the child was removed.
Right, but then, I mean, she has put together some troubling information. Whether or not it impacts the affirmance or not is a different question. But if you have somebody who's overwhelmed and you keep overwhelming them, that doesn't help the situation. And so not removing those tasks and really focusing her, was what was needed here. And her counsel's put together that didn't happen. And I don't see you confront that in your brief. So very pointedly, I'm asking you, were action plans backdated?
Well, the evidence, this theory on appeal was not tried at the case below.
Well, to be honest, I don't care. What I want to know is DCF backdating action plans, period. Because that's not acceptable.
We don't know anything about this because the evidence was not developed.
No, you can look at this record and you can make your own evaluation of whether she's correct about this, and you can tell us if the department was backdating action plans. You must have looked at this, because she's saying that there are action plans that were supposedly prepared by a social worker who didn't work for the department at the time of the plan. And just sitting here, if she's correct about that, and we can wander through this record on our own, which I don't recommend you let us do, or you can give us some guidance. She's wrong or she's right. But you shouldn't leave us to our own devices. You should say, yes, the plan was backdated, or no, it wasn't.
The tasks on these action plans were consistent throughout the history of the case.
I want to know if the DCF social worker was signing a plan with a date where they didn't work for the department, because that is not acceptable.
On the basis of this record, all we can do is speculate as to what happened, why it happened. Yeah, there appears to be.
Well, no, if that is what is the case here, how do we affirm that? Because then you have a situation where the department, it's just not acceptable. I mean, this is so basic, I'm not even going to explain it. You cannot have social workers backdating documents, period.
Let's clarify this. Sure, there appears to be an action plan marked as an exhibit that has a social worker's name on it and a date on it. And it appears that that date is before the social worker either joined DCF or became assigned to the case. But eventually, that social worker was assigned to the case, and the later date on that document is within the time the social worker was assigned the case. That's all we know from this record. It's meaningless. It doesn't tell us anything about who's doing what, whether people are backdating plans. It doesn't tell us anything.
I agree with you that it may or may not impact whether we affirm or reverse. But we need to understand that somebody, which here would be you, or it could be us, is telling the department this cannot happen.
If this was raised at trial, then it could have been vetted at trial. There could have been testimony about this at trial. And there would have been an explanation for why this appears to be this way. But on the record we have here, we have social workers testifying, when I got the case, I reviewed the action plan with mother, this is what the tasks were, she didn't do this, she did that, we have judges' findings. We have no finding regarding the significance of the date versus the name of the social worker on an action plan. So all we can do is speculate, which is not helpful.
In the record, we have at least one plan that has an actual, it looks like, electronic signature. That's at Record Appendix 2-155. A bunch of the other plans don't have an actual signature. Are they supposed to have a signature?
I can't answer that on the basis of this record. Again, there was
Well,
no
but you've
testimony.
worked for the department for a very long time, right?
I represent the department in court
Yeah. But
on
so,
appeal.
well, if I'm looking at RA 2155, it looks like these plans are it looks like the plan is supposed to have a signature, but then when I look at, there's any number of them. When I look at RA 2, page 22, it says signature information and there's something printed, but there's not the box that I see on 155. And then when I go to, 46 looks like 22, 69 looks like 22, but then boom, you go to 155 and there's a whole different thing.
Yes, there's no question there are spaces on these action plans for the signatures of both social workers and the consumer, the parent. But there is no testimony that I'm aware of that describes what is the purpose of these signatures, whether the document that's placed in evidence without the signature is ineffectual and the only valid one is with the signature. There's no evidence regarding that on this record.
Yes, but so look, we're in a situation where a large portion of our country seems to be willing to overthrow our government. And while I don't agree with that, I can see from the behavior of various government agencies, I understand where that flavor is coming from, particularly when the government is holding her to a very difficult standard, but the government doesn't seem to be holding itself to a difficult standard. And it doesn't seem like it's a complicated standard to be clear whether a signature is needed or not needed. And it seems like if you should be able to tell us that, and that we should not have that situation. So I'm unclear whether there should be a signature. She's indicated we have a problem, and I don't see a response from the department. And that's not a case-specific issue. Did you understand the concern anyway? Okay. Is she correct when she tells us that all three of, I think there were 4, but 3 of the relevant social workers who testified at trial acknowledged that they had failed to invite the mother to provide her appointments? Is she correct about that?
There is, well, yes and no. There is evidence that one of the social workers failed to invite the mother to the IEP meeting.
Right, but she's saying it's much broader than that.
There was a meeting that was made up, counsel described that, and the judge found that missing that one meeting did not undermine a finding of reasonable efforts. There was a social worker testified that she did not invite the mother to medical appointments. Although there is evidence that it's not exactly how mother portrays it on appeal. So, for example, there's this reference to the meeting at the Boston Children's Hospital. This is at page 8 of the reply brief. And there's this argument that the social worker admitted that mother was excluded from the meeting at the Boston Children's Hospital, and grandfather brought the child to that. The problem with this is that the evidence, let's see if I can find you a citation, the evidence was that the provider at Boston Children's Hospital told the social worker not to invite the mother, that it was not necessary. It's actually the same transcript site that is in the brief, transcript 827. During that testimony, the social worker said the provider was doing an interview of the child and that mother was not necessary, and basically told the social worker not to bring mother. It was not necessary. So mother has now converted that into DCF has refused to include mother in meetings like this. This is the problem with the appellate presentation here, It is retrying the case in a way that the evidence does not support. So yes, there are occasions when social workers admit, we didn't invite the mother to this or that appointment, we should have, but not to the extent, and I do ask you to look carefully at the record, because it would show you that the depiction on appeal is not entirely accurate. So, for example, this point about the autism services provided by UCP, that was the reference was to finding 337. Well, let's look at finding 119.
I think we understand the tenor. You're 5 minutes over already, so I think we'll have to leave it
I'll
at that.
finish this point and sit down. Finding 119, the judge finds that UCP could work with mother even if not in her care. And this service was meant to provide mother with support for herself in understanding autism. But mother's presentation on appeal is that UCP would not provide the service to her unless the child was in her care. This is contrary to the judge's findings. So I would just ask you, in light of all of the evidence and our brief, to affirm the ruling below. Thank you.
Thank you.
Before I forget, does that make a difference?
Good afternoon. May it please the court. Douglas Rose on behalf
Just remind everybody, we're impounded case, so no names of kids or parents. Thanks.
Thank you, Your Honor. Douglas Rose on behalf of the child appellee.
You can say your name. Yeah.
Sir?
You can say your name.
Oh, yeah, that's what I thought. Judge Massing, you prefaced your remarks this morning about brevity being the soul of wit, I think was essentially what you said, and I think we've covered a lot of ground today. But I have three points to make. First of all, and that they don't pertain to mother's marginal unfitness. We really need to look at the best interest of the child in the light of mother's marginal unfitness. The child has these special educational, emotional, psychiatric needs that mother did not address. The grandparents have made great strides in nurturing this child, and the child is self-aware, and he supports the decision of the juvenile court. This court knows that.
So repeat that again. The child is self-aware. Did you say?
Yes, sir.
Okay.
Yeah, he's 12 years old, and although we've heard a lot in the record about his problems, he's self-aware, and he supports the court's decision. There were 3 C&Ps in 7 years. The first 2 were relatively short-lived, but the last one was the one that brings us here. When he was 4.5, he was observed by Dr. Kaplan while he was in DCF custody. Dr. Kaplan says that he's got feral child syndrome, and I think the mother's testimony was explained in a little bit more vernacular terms, Tarzan syndrome. This was attributed by Dr. Kaplan to a lack of parenting of any consistent quality, that the child met the criteria for autism and post-traumatic stress disorder, and that he was at risk of additional psychiatric issues, and he needs a caring, warm, supportive, and nurturing household. He needs intensive, developmentally appropriate supports, without which he will be very likely to not improve. Later on, Dr. Kaplan opined that he traced the child's issues to substance exposure in utero and the environmental history with the mother. And again, he called for secure, stable, and developmentally informed home environment, such that the caregivers need to understand his diagnosis and advocate for services. And that's one of the interesting points we made before about the action plans. They're not self-executing. Action plans need to be proactive on behalf of the parent or the prospective caregiver, and the parent has to be seeking services. This didn't happen in this case. When Dr. Ellingwood observed the child at age 6, when he was still in mother's care, he was not toilet trained. He didn't relate to other children. He couldn't speak. He can't focus. And Dr. Ellingwood said he requires significant assistance with daily living. After his removal, Dr. Rutherford, when he was 8 years old, Dr. Rutherford, the psychologist, took a look at the child and said, he has these severe symptoms of autism, and ADHD, and Dr. Rutherford concludes that he might not be able to function independently as an adult based on what he had had up to the age of 8. So the unrebutted clinical evidence was clear and convincing that this child requires, as does every child, stable and secure parenting. So my second point is that the grandparents at the time of trial were proven to be those capable caregivers. He was placed with them right at the inception of the proceedings. They have a spacious home, a fenced-in backyard. He has his own bedroom. There were no safety concerns. They were financially provident. They managed his hygiene. They managed his nutrition. They managed his appointments. They did all of the things that he had never had done up till the age of 8. They were proactive, the grandparents. They were not reactive, like the mother was always sort of half a step behind. The grandparents were proactive. And the trial evidence is also clear and convincing that this child has made vast improvements in the grandparents' care. Speaking, going to school, he's happy and healthy.
Actually, the record is kind of contradictory on that. I mean, you cite the testimony of one of the social workers as saying he's speaking better, but you actually cite Dr. Rutherford, who says that he hasn't made very much improvement, which is
Dr. Rutherford examined him right after he was in custody. But the social worker,
it was like a year. She said something like that she would have expected him to make more progress, which is why she thinks it's actually a very deeper, a deeper diagnosis than they might have thought.
Well, in any event, Judge, I'm running out of time, and I do want to keep my remarks brief. I would suggest to the court that the last point is whether this child, when we didn't really discuss it yet today, but the conclusions about visitation with mother. The grandparents know this woman. They are her parents, and she'd never provided any kind of consistent quality parenting. She had a haphazard lifestyle, but the grandparents should be, in their sole discretion, the monitors, the supervisors, the caregivers who allow visitation at their discretion. So just briefly in conclusion, the child submits that the adjudication and orders of the juvenile court should be affirmed in all respects. If there are no other questions, my remarks are concluded.
Thank you. Seeing none, thank you all. Your Honor. The case is submitted, and that'll conclude our court for today. I want to thank court officers back with us from the beginning, and the clerks, and we'll be in recess.
All right, please. Court is now in recess.